Hey, what's up, guys? Welcome to Lawsplaining the Interwebs. I'm your host, Nick Rekieta of Rekieta Law, a small law firm in central Minnesota. And with me today is Mr. Robert Barnes. How's it going, man?
Good. Happy to be here.
Yeah, thanks. Welcome to the show. And, well, I guess I brought you on. I was drunk watching the presidential debates. And
Were you doing like a drinking game, or was it just you happened to be drunk watching it?
No, well, I was watching it with a Texas attorney, a friend of mine named Ty Beard. We were just kind of reviewing it, drinking whiskey as it went, and I flipped over to Twitter to tweet something out, and I saw something you tweeted. It was perfect, so I retweeted it and invited you on the show, and here you are. So
Happy to be here.
I'm glad it worked out that way. But you
Perfect.
are, maybe I could let you kind of describe who you are to the audience. I think many of them are familiar with at least some of your work, and if not your work, your commentary. So if you could give us just a quick synopsis, that would be great.
Sure. So about a 20-year trial lawyer, civil cases, criminal cases, constitutional cases. The primary reputation was in civil and criminal tax cases, but have handled cases across the board, across the country, across the globe. We represented a range of high-profile people over that 20-year time period. Pretty much everybody across the political spectrum, from left to right, from Ralph Nader to Alex Jones, from Wesley Snipes to Joe Francis, from Libertarian Party to the Green Party, you name it, everybody in between. And probably the most recent high-profile case has been representing a bunch of the Covington kids, not Nick Sandmann, but all of the other Covington boys, or a lot of them, who were defamed and slandered on that day against a bunch of politicians and high-profile public personalities and press people and the rest. And then usually have a couple of high-profile cases going at any given time. And then the political commentary came as sort of accidental. I mean, my whole Twitter thing was accidental, and all that happened is I've been a political gambler and a sports bettor. I live in Las Vegas, have offices in California, Tennessee, and Wisconsin, licensed in all 3 states. Member of a bunch of federal courts, of course, federal appeals courts, district courts, you name it. Western District of Texas is one of them, where I'm a general member, even though I'm not licensed in Texas as a state.
Sure.
Because I was monitoring the 2016 election, I wanted to figure out how best to bet. And so I didn't know what Twitter was. I saw that weird bird thing. I was like, okay, whatever. Apparently this is a popular way for people to interact. I want to monitor it. And I use it as sort of an internal curational tool. And it just sort of took off. So I had like Law and Crime and people at the Dan Abrams Network wanted me to comment on tax cases because there's a lot of Trump controversy. And then I won a big bet on Trump in 2016, and that got a bunch of coverage in Dublin and London, and then ultimately the United States. And so that just put me on a different radar screen. So even though I'd been prominent in certain legal areas, I wouldn't say I was publicly prominent until the Trump bet went big.
Right. But now you're like a pretty prominent commentator on a broad variety of issues. And then when you combine that with the high profile cases you take on, including, of course, the Covington kids, that sort of is, I guess, exposing you to the internet.
Yeah, no doubt about it. Like, people occasionally get agitated about I still use Twitter as an internal curational tool.
Mm-hmm.
So I just tweet. It's like my own personal library, and it's just a lot of people end up having interest in what was in that library. But I'll still get people like, man, why are there 50 tweets out? It's because I'm just commenting on anything I find interesting and grabbing notes and stories. Sometimes I agree with them, sometimes I disagree with them. But the other thing that was happening is sort of popularizing access to the law and understanding of the law, like what you do with your show.
Right.
I see that as I'm an old school populist, little d Democrat. So I believe in giving people more information, more education, more understanding. I don't like the way that, if it was up to me, there wouldn't be a bar. Anybody could be a lawyer. Just go out there and say what your skills are, say what your education is, say what your experience is. Let people choose. And then we could democratize access to the law in a much more dramatic way than is currently available. And so as part of that, I decided to start getting more involved in public commentary, and especially in the Trump era, the professional class has become so political and so anti-Trump and so elitist, really snobbish often.
Very much.
Like I know on civil law, for example, he did a commentary on a brief that you had filed, and then these snobs just sort of attack him on Twitter. And it's just like, it's that I hate that snobbish attitude and demeanor. And then they're also just flat out lying to people about how the criminal process works, lying to people about how the civil process works, all because they hate Trump so much, lying to people about how the Constitution works. So I just got, I used to tell people that I'm my best as a lawyer when somebody ticks me off.
Yeah.
And so it became just a matter of, I would just get agitated. That's how I got involved in the Covington case. I was on vacation in Mexico and I saw what Maggie Haberman said, and it just made me mad, and said, well, I'll help anybody out for free who wants to sue Maggie Haberman. And I come back from Mexico and it's blown up. All of a sudden I'm on Fox News the next morning, getting to tell everybody if they don't retract and take it down, that we're coming for them. But there's so much inequality in the law, in education and information, that makes it tough for ordinary people to know what their rights are, know what their remedies are. And so it became highlighted in the Trump era, and shows like yours popularizing access and understanding to the law. I wanted to be a part of that to help contribute to it, particularly going up against what a lot of the elites and snobs and most of your news media lawyers are not real practicing lawyers. I like Dan Abrams, God bless him. He hasn't been a practicing lawyer, if ever. So they were saying things about the civil process and the criminal process that were just wrong, in my view. So I was an involuntary participant, like an involuntary public figure in a defamation law. That's basically how I became a public figure.
Yeah, and that's it's interesting that you bring up like news media lawyers, because I was in law school when the Obamacare decision first came down. These guys are handed like 150, 200 pages of Supreme Court text, and they're like, here, we're going live in 35 minutes. Please summarize this. And so what you saw were the initial reports on the Affordable Care Act decision were fraught with errors, misstatements, and misinterpretations of exactly what was going on, or they got to one part of the opinion, they didn't get to the other part involving states' rights. So Roberts, depending on what channel you're watching, is either getting praised or blasted. And then it's like, oh, when they got to the rest of it, they had to go back and do the opposite. So it's an interesting world, and I do think lots of people forget that. Well, they overestimate the amount of expertise any one person has as well.
Oh yes,
and that's especially true in journalism. So the way I say it is, I'm an idiot like you. I just know a few things about something specific. I
mean, all these journalists are kids. Almost, they're all in the 20s, young 30s. If that's a senior journalist in Washington,
right?
And they all come from the same class culture. They're upper middle class professionals. They come from affluent suburbs in the East Coast or the West Coast, or maybe a place like Chicago. Diverse is living in the upper middle class part of Dallas or Houston. I mean, this is not. They don't understand or recognize life experience. And law used to be a profession where at least some portion of it had working class roots, and you had great trial lawyers and people who helped make a difference, and people who could tell a story and understand the law at the same time. People like Clarence Darrow, people like Jerry Spence, and just more and more of them were fading out. It was like I tell people often, my best skill in the law is that I don't have the disadvantages and detriments of the people that are on the opposite side of the law. It's not, the not being handicapped the way they are. And it's been extraordinary.
Right. When I was, that was one of the things. I was late going to law school. I was in my 30s when I started. And so I had been out, I had worked, and then I was going primarily to night school at first, because of commuting and all of that stuff. And then when I started integrating into some of the earlier daytime classes in my third and fourth semesters, and I'm running up against kids who are 22, 23 years old. And I'm like, you went high school, college, law school, and you're going to come out and handle someone's divorce? Like, do you know married people?
90% of the of legal education is useless that you learn in law school. There's about 10% that's worthwhile. If all you're going to do is ever argue to appellate courts, then it has more utility than if you're going to be a trial lawyer. And this is why I disagree with the bar. I don't think there should be a monopoly on the practice of law. The real skill set is accessibility to ordinary people, ability to tell a story, ability to relate to a wide range of businesses and lifestyles and life experiences.
Right.
None of those things are coming out of law school. And the fact that you have to go there for 3 years, the fact that you have to borrow as much money as you do, it nets out to being a privileged profession of people who are disconnected from the people they're supposed to be helping out. And so it doesn't really, we are hurting the quality of justice in America by the monopolistic practices of the state bars.
I couldn't agree more. In all honesty, that's very well put. So, what I wanted to do then, I guess, is talk about what your opinion is on how kind of the wide exposure of the internet might impact people's practice of law or their sort of, I guess, unofficial education of other people. One of the people that comes to mind on that, who has a large following online, is very popular, is of course Ken White, otherwise known as Popat. And I notice he had kind of a tweet the other day that was verging into conspiracy territory, which is something he's highly critical of, involving Trump's COVID diagnosis. So you had mentioned talking about it, but even though I voted for it, I think it lost in your poll on what to cover.
Right. Well, I mean, there's no question that, I mean, Popat is a sort of perfect, emblematic example of what I'm talking about. That the only people in the legal public education space, when I started getting involved in this, were your Popats of the world.
Right.
And they're arrogant. Now, he at least practices law. He has a pretty good legal reputation in terms of his career, in terms of his profession, both in criminal defense and in defamation law. But once Trump came along, he suffered a severe version of Trump derangement syndrome, and he started making statements that were just flat out false, about inaccurate statements about the law, very questionable opinions about the law. And I mean, the best example was basically saying that everybody connected to Trump or Trump should all be in jail because of his interpretation that they deliberately, because he misinterpreted the information is what happened. He misinterpreted what a doctor said at a press conference. So he got the facts wrong. And then on top of that, he got the law wrong, because I mean, especially he in California has to know that you can't even prosecute someone for giving someone HIV unless you can prove they intended to give them HIV. So how is it you're going to be able to prosecute someone for spreading COVID? I mean, that's insane. So he was on a conspiracy kook theory about how maybe it's all fake or maybe it's this or that. So there's that nutty behavior. And he loves to sneer and be snide. He's such a snob. I would challenge him to debate anytime, because he couldn't hold up for 10 minutes. The guy's a fraud. The guy's a phony. And what I mean by fraud and phony is that he holds himself out as better than everybody else, as smarter than everybody else. He looks down on people who disagree with him. He's arrogant and condescending towards those people. And in the last 3 years, he's been wrong a lot more often than he's been right. So that's why I have zero. People like him drive me nuts.
He loves me, so I have to disagree with everything you said. No, I'm kidding. I got blocked a long time ago by Popat.
He blocks a lot of people. He won't block me for whatever reason, which surprised me, because I'll take a shot at him once every couple of months. Just because the thing is, if he just disagreed and was one of these crazy lawyers, fine, so be it. It's that he's such an arrogant ass to so many people that I just can't. It's like my one trigger is snobs.
Sure.
So he drives me nuts. And when he's a snob and wrong, then he deserves to be called out for it.
It's doubly bad. What about so then there's one other guy. You were addressing this with Viva the other day. Legal. Yes. He filed, what was it, a Freedom of Information Act request over, was it a book?
It was two. I think. Well, I don't know if he ever filed his second suit. He said he was going to sue to defend the park from Trump and all that jazz, Lafayette Park. He was crying on his video, and he's another example who the big tech people are favoring. So you have the big media types, which are all elite snob types who are pushed out there. 2/3 of whom, unlike Popat, don't even really practice or haven't practiced law very often, and the other third are your legal types who practice maybe for a few years. Fine, no problem. But YouTube promotes them because his politics is what they like. And so the ordinary young person or other person who gets their legal information from YouTube gets it from legal. And he's consistently wrong. His politics are so, when he was just commenting on TV shows and loose suits, he would do enough research to be, a first-year law student kind of interpretation. Not great, not terrible. But once Trump came along, he would just make stuff up or just get it badly wrong. So his tax interpretation was just, it was a migraine listening to his presentation. It was wrong. And he started doing this with Flynn and on anything Trump related. He's going to make snide comments, which undermine his presentation value to me rather than help his presentation value.
Right.
If you're going to be an independent lawyer making a legal analysis, and all of that, it's my problem is that YouTube is promoting him. So like if he wasn't being promoted, I probably wouldn't care. Okay, it's just another lawyer who hates Trump who got the tax law wrong. No big deal. But the reason why I went after him is because he's being promoted by YouTube. The number one YouTube view. Oh, absolutely. The number one YouTube view on this issue will be Legal Eagle's version of Trump's taxes. And it's littered with misinformation, which YouTube says, oh, we're totally opposed to. No, you promote misinformation routinely and regularly that serves and suits your politicized purposes. And so that's part of the reason why I engaged him on that subject. But he's awful. He's really...
he loves me too. No, actually, I have no idea if he even knows who I am. But I make fun of him all the time. Did you see his Brie Larson as Captain Marvel?
No, I've heard people comment on it, but I've never seen it.
So I'll give you the skinny. There's a deleted scene from Captain Marvel where Brie Larson shows up and she's looking at a map, right? Like she's got a fold out map, and this guy comes up and he like grabs the top of her map and kind of pulls it down, looks over, and makes some sort of pass at her. So she proceeds to grab him, break his arm, and then steal his clothes and his motorcycle. And Legal Eagle said that was a justifiable use of force because of the battery of him touching her map.
Wow. Oh, I mean, and that's what I mean by this is woke law, right, which is just bad law. It's not good legal analysis. People are getting bad information. Many of them are going to act on that information. And that's what makes it problematic to the core. So it's troublesome. What has happened is you've had three types of lawyers that have got into the sort of this space. And one are your corporate types, media shills, snobs like Popat. Second are your giving woke legal advice, which is bad legal advice like Legal Eagle. And unfortunately, the third has attracted the Avenattis, the grifters. The grifters have glammed on to social media as a means of making themselves popular, and as long as their politics are on the right side, they get promoted, or if they learn how to work it. I think that right now we have people on the right that are mirroring Avenatti style problems down the road. But the right, of course, is making the same mistake the left made. I knew Avenatti. We had crossed paths in representing Joe Francis. Everybody, I knew exactly who he was from day one. And when he started getting promoted, I just started putting up to everybody. I was one of the first people I ever publicly outed was Avenatti. And I just went after him and detailed everything about him. He blocked me, of course, very quickly. But I was trying to tell my liberal friends in the media, it's like, you should be nowhere near this guy. Yeah, this guy is radioactive.
Terrifying guy. I'll have you, I have to preface this because of full disclosure, requirements, ethical obligations, that I did recently win the biggest grifter of 2020 award on an internet poll. There's actually a trophy and everything. So I'm firmly in the grifting category, but that's okay.
Well, that's what annoys me the most is the people that get attacked for grifting. So it's the grifters who attack everybody else. So you have like Robbie Sove at the Reason and Libertarian. That's fine, no problem. But when he goes after other people, and Reason's on the Koch Family Foundation payroll,
Oh
And that's why
man.
they're out there promoting Amy Coney Barrett, even though she has one of the worst civil liberties records of anybody that could be nominated. Why? Because the Kochs want her on there, because they have certain positions on big tech and monopoly that they care about more than they do about civil liberties. Well,
Right.
what's Reason doing? They're taking the one halfway decent case she did and citing that as the example of how she's an exemplar of protecting civil liberties, which to every civil rights lawyer in the Seventh Circuit was a bad joke. So you have somebody promoting a Koch agenda, frequently contaminating their what they claim to be their ideas and efforts of that, going around and attacking Candace Owens as a grifter. And I'm like, what are you doing attacking anyone as a grifter when you're the ultimate? It's all these Washington insiders. I had people attacking me as a grifter on the Covington case. And I'm like, have you, number one, I'm doing it for free.
It's pro bono.
Where's the grift? And the second thing is, I could just be I didn't need fame to make money at all. In fact, I lose money by doing all these pro bono cases, and I can't get a money value equivalent of what I can do in the tax arena. I could just go back into just doing tax, civil and criminal, make a lot more money than willing to put my reputation at risk, willing to put my legacy at risk, willing to put my name at risk, willing to be politically attacked, personally attacked, professionally attacked by wanting to engage in the public arena, what I think are problems in the public arena about the fairness and equality and education level we have about the law. So it was an absurd, but what's amazing is the actual grifters are the ones who are accusing other people of grifting when they are the actual, and they don't hardly ever get called out for it. Avenatti got called out by people on the right, but nobody on the left really. And there are people right now on the right that really fit, that have all the hallmarks of Avenatti. And I've been the only one that's been, hey, look out, hey, be careful, hey, this could be a problem. And all I do is get pushback and attack, of course. So it's the nature of the animal.
So I want to talk about a big case right now with someone who I'm kind of undecided on whether or not there's grifting going on or whether or not this is just there's some genuine screw ups. I've seen you've comment about this a little bit. It's obviously Kyle Rittenhouse and Lynn Wood. I know Lynn Wood has a checkered reputation depending on who you talk to. He did some interesting, some very good stuff for like Robert Jewell. He's done very good for Nicholas Sandmann so far. But then with the Rittenhouse, we have, I think $2 million has been raised for GoFundMe, until GoFundMe threw that off and then they went independent. And now there's, of course, the problem with the independent part is there is no public accounting of what's going on like there is with GoFundMe or whatever, where you have a running tally. But allegedly they're over $2 million. But then there were some problems with one of the defense attorneys. So can you talk about that at all? I mean, I looked at the Rittenhouse videos and I thought, okay, they're definitely going to charge this kid. They probably should charge him based on the videos because of how I figured they'd write the complaint. Then I read the complaint and I was like, why'd you bother charging him? You wrote a self-defense narrative right into the pleading. This doesn't make any sense. So I think he's 100% innocent of any criminal wrongdoing. But that being said, I look at how it's going with Lynn Wood and these other attorneys, and I'm like, okay, is Lynn exploiting Kyle here? Is he exploiting the situation, or is it just fortunate that all these people are looking? What's your take on that?
So it's a couple of different things. One is, I think there's various lawyers that think my strategy was deliberate. So I've run into lawyers that are trying to imitate me in different respects. So they're trying to get politically involved and make political commentary. And I just said whatever I felt like saying for my own sake. There was no planned out agenda behind it whatsoever. Right. Nor is it, like I said, I lose money this strategy. I don't gain money. I'm doing it for other reasons. Same reason Scott Adams comments. He lost money the moment he started talking about Trump. That was the end of his speaking career, and that was very lucrative for him. So so I think that's a little bit of what's going on of how I've ended up dealing with these people because they follow me and then they start imitating me, and then in other ways they start showing up on my radar screen, and then I get questions asked by other people. So there are several different issues. What Rittenhouse needed was a sophisticated dream team criminal defense that was very knowledgeable in state criminal law, that had experience in Wisconsin, some extradition experience. Because extradition is pretty uniform, you don't need Illinois-specific extradition experience. But it'd be good to have a politically connected Illinois lawyer to know who's who and who the actors are, who the players are.
Right.
And the other thing is any money raised for him needed to prioritize bail, number one, because you can't have him sitting in jail for 2-3 years pending a trial. And second, for his family, because his family's poor. They're not going to be able to, he's not going to be able to do a regular job while this case is pending. So
Right.
they need to be, and the security would be a major risk factor for what they're dealing with. And he's got a little sister. So that needed, and then priority 3 would be paying the lawyers. And my view was, if you did it right, you'd get lawyers volunteer some of their time on this. This
Right.
case is high profile. You win this case, you get a lot of, and like you said, it's factually a very good case. So this is a high probability of winning. You can win it, but the media doesn't think so. So it's a perfect combination. If you're in the state criminal defense realm, you can make your bones on this case. You can become famous on this case. So I thought that, hey, you could raise all this money, give it to the family, secure his bail, make sure they're safe, make sure they're economically taken care of, and you could put a dream team, 2/3 of whom would do the case on the cheap discount.
Right.
And there was enough money raised for that to happen. So what originally, as soon as Wood, I ran into problems with Wood on the Covington case. And that's a much longer story, but it involves other political actors. And I was shocked. I was volunteering my time pro bono. So I was like, why am I facing a political war from people behind the scenes in Covington? People were coming at me to try to prevent people from retaining me. And I'm like, this is a first. I've never been a target to have for representing people for free. And all kinds of smears, false stories, other stuff. Later on, I realized it was political. There were people who did not want Salmon in particular to sue individuals, only wanted him to sue big media institutions that are basically insurance companies, but politically protect the politicians, politically protect individual members of the press, politically protect individual celebrities. If you'll note, Nick Salmon hasn't sued a single individual, only insured companies.
Yep.
After Wood made all these, I'm going to send out 50 letters and to all these individuals, he never sued them. And then he kept trolling me on the internet. So my interaction with Wood was through the Covington case. It was not a favorable one. I was like, and he did things in the case where I had to get proactive earlier than I expected, so I could get back in front of that federal judge while that judge was considering motions for reconsideration. So the judge would perceive the case differently than when you sue for $200 million plus, folks. The federal judge's reaction tends to be, you're not a serious lawyer. This is a political ploy. You're not really suing unless it's, two corporations fighting.
Right.
The biggest defamation award in the history of Kentucky in any kind of even semi-comparable case was $100,000. 30 grand back then, but 100 grand in today's dollars. So that gives you an idea of what they're used to down there. So I needed to have a different political portrait of the case, and certain legal arguments I wanted to make. And so I had to accelerate my timetable. Ultimately, it all worked out to Salmon's benefit, in the Lynn Woods benefit, but I still got attacked from Wood sporadically. So, and he would go around lying about me to different people, and he'd go to do a commencement speech and lie about me. And it's like, what the heck? And mostly I didn't care. I was just like, there's something off here. Yeah. There's something weird here. Then he jumps into the Rittenhouse matter. And apparently they went up and directly solicited the mom and Rittenhouse to be signed up. Well, You're not really, apparently both Wood and John Pierce.
I was saying, like, that's not quite proper. If you do that directly,
and especially when you're not even licensed in those jurisdictions in that way.
Yeah.
And so, I don't make a big deal of that because I think a lot of the solicitation rules violate the First Amendment. But I was like, okay, why is he jumping into this case? This isn't his world. I get if it was a defamation case, he thinks he could do well, fine. This is a criminal case where Wood doesn't do criminal law. And he admitted he's not doing the criminal case at all. And he brought in John Pierce. And I knew about John Pierce because he's got an Avenatti-style reputation in L.A. It's law firm after law firm that he's involved with is breaking up. He's facing lawsuits all over the place. His wife is taking out domestic violence orders against him. I mean, the guy's a walking, talking Avenatti level disaster.
Sure.
And not only that, he has no experience in state criminal defense that I'm aware of, no connection to Illinois or Wisconsin. I was like, what in the world why is Wood bringing this guy in? It's like, this spells disaster 100 ways to Sunday.
Yeah, I didn't even look into him. I just assumed that he was going to be local counsel there in Wisconsin. But you're saying this guy's an LA guy. And okay, that makes even less
owes massive debts all over town. He got people to lend him a huge amount of money to bring a bunch of crazy suits. You may know about litigation funders.
Yeah.
I don't take money from litigation funders because there's problems when you do. The ability to take money from a litigation funder and that not compromise your case, I think, is just very, very hard. And not only that, the other thing is the people who run litigation funding organizations, I find to be some of the least competent people I've ever met. They have these Wall Street funds hire these corporate associates to evaluate personal injury in plaintiffs' cases.
Right.
And so they have no idea what they're doing. I had one of them who came to me, pitched me, wanted to get involved. And I had a case where a client was willing to do it because we needed cost for trial. And we were right at the edge financially to get all the cost for trial. And I said, well, okay, it's a great case. We're right on the eve of trial. And they were like, oh, you're on the eve of trial? No, we only want to get involved earlier. I was like, hold on a second. We've already won the motions to dismiss. We've already won the summary judgment motions. We've already won the appeals related to those issues. This is when they're most likely to settle the case on the eve of trial. And you're telling me that's when you don't want to fund a litigator? I was like, wow. I was like, never mind. Just go home. I'm not gonna do business with people that are too dumb to do business with.
Right.
But apparently John Pierce knew how to hose him. Because, I mean, I'm talking tens of millions of dollars he was taking. I mean, he owes debts everywhere. He was getting all these small New York people to give him payday effectively loans, $300,000 here, $200,000 here. And he was using as collateral a bunch of his cases that didn't pay off. So, and he keeps changing the name of his firm from one entity to another entity to another entity. He's trying to stay one step ahead, just like Avenatti was when he started all this, of his creditors. And it was clear to me from day one, Avenatti's goal was to try to bail himself out by getting a bunch of money from a bunch of people by being political. He also thought he could get himself immunity from criminal prosecution by doing so. And Nike was supposed to be his big payoff case.
Right.
He just didn't realize, extortion is still a crime.
Yeah. It's an unfortunate aspect of that case for him.
Exactly. All of his other crimes, stealing from his clients, not paying any. I mean, he managed to not pay any tax anywhere. I probably had a role in him getting prosecuted, not only because of my public attention, but anytime I talk to the tax division, because I have a lot of cases in front of them, I would say, look, I don't know how you can prosecute my client as long as Michael Avenatti's walking around. I mean, it was just, and it clearly drove him crazy over time. Because I was like, you got a lawyer, high profile lawyer, is going to run for president, and he's cheated on every single tax known to man: sales tax, unemployment tax, property tax, income tax, you name it. And everybody knows it, and everybody's known it for years. And you got a scam artist. So that was the backdrop for when I saw Pierce. I was like, this is bad news. Not only does he not well equipped to do a case like this, he's got massive financial problems. He's going to use the incentive for him to use these funds raised for Rittenhouse's defense to take care of his massive financial problems is off the charts. And the risk that he tries to become a right-wing version of Avenatti, where he becomes fundraising for all kinds of bogus cases, that risk was off the charts. And at the same time this was happening, Lin Wood was being sued by every single lawyer who worked for him. Right. All of his partners sued him, which for folks out there, that's unheard of. You don't see that happen. And what they were detailing, it partially explained some of his behavior that I had to deal with, was basically he's losing his mind. He's on the QAnon bandwagon, which was a great way to build up your social media. If you want to, there's tons of YouTube channels. There's people that take pot shots at me on YouTube randomly. Someone will send it to me, and it's because they're QAnon people. They're still mad at what I said about QAnon. But basically, if you want to easily get followers in the social media space, jump on the QAnon bandwagon. And I just don't trust any lawyer who would do that, because you don't have to be a genius to figure out QAnon is not a credible source of information and reliable, trustworthy, predictable source. I know a lot of people get emotional about that, but that's just reality, folks. If you want honest opinions you can't be on the QAnon bandwagon because there's no lawyer who down deep believes it unless they're a little bit off. And what they reported in the lawsuit is that, he thinks Justice Roberts is going to be removed. He's going to become Chief Justice. Just crazy stuff.
Wait, Lynn thinks Lynn is going to be Chief Justice?
Apparently, that's what he was telling other lawyers. See,
Okay.
Now imagine if you're Rittenhouse and you're seeing all this weird behavior where they're not, they don't show up at his first extradition hearing. When they show up at his second extradition hearing, they admit they haven't even looked at the paperwork yet. And then after that, they filed a motion to bring in evidence to review with Rittenhouse, which means they hadn't even reviewed the evidence in the case with Rittenhouse for over a month,
right?
Which was a critical time period as a criminal defense lawyer. The first thing you do is talk to him. You get all the intel. You hire an investigator. You lock down statements before people can have selective memories later on. Apparently, they've done none of this. So it's like for Rittenhouse, at first I wasn't going to say anything. So it's like, okay, this is just weird, but I'm not involved. Not my issue. Not my concern. But I am licensed in Wisconsin and went to law school in Wisconsin. So all of a sudden, a bunch of people in Wisconsin started reaching out to me, and from other states also that were state criminal defense lawyers, saying, one, this is a disaster, what's happening. And Wisconsin lawyers were agitated because I had generally never said negative things about Lin Wood publicly. Even though he's out there smearing me in random places and libeling me in random places, I didn't care. It wasn't my issue. And it didn't benefit me to get into a fight with the Nick Sandman lawyer when I'm representing the other Covington kids.
Right.
I was like, I don't care. It's not my issue. But they were agitated because it was perceived that I had validated and vouched for Lin Wood. And they were like, this guy's a disaster. Several high-profile criminal defense lawyers were going to be involved. And they said, we refuse to be involved with the Rittenhouse case as long as this shit show is going on, in their words. There's other information I can't get into, but it was information that led me to be, oh, wow, there's a serious, serious problem here.
Sure.
And so that's when I decided to go public. And my only focus with Lin Wood was, Lin, just give the money to the mom. And then she and Rittenhouse can use it as they need and can pick their own counsel. Because my concern was that because they had effectively hijacked their legal defense by monopolizing all of the funds for that legal defense. And then there was also my concern that what they were saying about Wood, I could imagine a scenario where they're telling Rittenhouse, hey, Rittenhouse, don't worry, the president's going to pardon you after he gets reelected, which of course can't happen because it's a state crime. But I could see, I was like, the family's reacting very calmly while the extradition is, while he was, rotting in jail, while there's no defense being mounted. Essentially, I think Rittenhouse has a great case, but it is not in good hands with those two. Now, they did ultimately find a local Wisconsin lawyer who was willing to deal with them and sign on to the case, and he has a good, solid reputation. But the rest of it, I have zero confidence in, and it's not clear to me how much influence he has, because I am aware that some of the best Wisconsin criminal defense lawyers who were willing to be involved refused to be involved once they dealt with Wood and Pierce.
Sure.
And so basically Rittenhouse is in harm's way, but if I say anything about it, I get the Q. I went ahead and did it anyway. I don't care. But I get the whole QAnon army against me. I get Wood libeling me all over again. I get all of that nonsense, but I would not try. What I told people is I wouldn't hire Wood for anything. That was just my experience. Make sure that, my past nice statements were not misinterpreted as vouching or validating the guy at all. Right. I don't want to be one of those people that they think have vouched for Avenatti, an Avenatti type problem. And John Pierce is the second coming of Avenatti, in my view. He has all that tattooed on him. And the right is, people like Michelle Malkin are out there vouching for him. They're on the fundraising circuit at Republican Party events. And I'm like, folks, we're going to make the exact same mistake we made fun of people on the right for making fun of Avenatti on the left.
Right.
And this guy's got 100 problems, and nobody wants to pay attention to them. Lin Wood, they're detailing all kinds of things, personal threats, calls early in the morning, anti-Semitic comments. He asked for his other partners to refer to him as Almighty Lin. I was explaining to people, I was like, this is not just some fee dispute, folks. If you think three young lawyers who were partners with Wood for 3 years, who did probably all of the work on the Sandman cases, if you think they're willing to risk their careers by signing under penalty of perjury verified complaints, then seeking a temporary restraining order because Wood was basically gaslighting his audience to threaten these people personally, and they were starting to get personal threats, signed additional affidavits seeking emergency relief. If you think they're willing to take that risk, then you don't know that legal field. If you're a young lawyer in that situation, usually you just want to break up with Wood and that's it.
Quietly
you never
go
want to
work.
get into a public dispute with a guy who could kill your reputation. And so for them to do it told me this is bad. Lynn has jumped off the bridge.
I haven't been following his personal dispute with his partners, but one thing that really concerned me was during the debate when Biden, of course, takes his shot, calls Kyle Rittenhouse a white supremacist, and Lynn Wood's like, "I'm going to sue Joe Biden." It's like, oh, okay. I mean, I get what you're doing with Sandman, but that's a little bit different. Can you help me articulate the differences?
There are two things there. What I had said was, first of all, I would sue Chris Wallace. And the reason I would sue Chris Wallace is because Wallace initiated that conversation by putting Kenosha in the same phrase as white supremacist violence. Now, knowing that my chances of winning were low, but the reason would be to deter the media from saying, hey, you want to gamble on whether a judge is going to agree with me or not?
Right.
And deter that. And if he was serious, in my view, that's who he sues out of the gate. Suing Joe Biden just looks like a political suit. It's not going to gain, the media's not going to pay any attention to that, and they didn't. Whereas Chris Wallace, they would pay attention to. And if you sued him individually, that's why I sue media members individually, because if you want to make change in the defamation space, you don't do it by suing big media companies who have insurance companies write checks for them. They don't care. They shrug their shoulders, part of why they pay insurance premiums. If you want to change the equation, you sue individuals, because then all of the other individual members of the media class pay attention. Because when they're personally at risk, personally professionally, personally monetarily, they might not be indemnified for the judgment. They might not even be indemnified for the legal fees. Then you get them to pay attention. So that was my view. But you're right. Like, all these people are jumping on it. Oh, it's going to be a great suit. He's going to bankrupt. That was the other thing, is they were saying crazy stuff, either he or Pierce. Like, they were going to bankrupt Twitter. They were going to bankrupt Google. I was like, okay, no, none of that's going to happen.
You're not bankrupting Google.
They have no chance. Good luck with that. But I sued Twitter in a case that had the best chance to win, with a Republican judge and a Republican jury pool, and she made clear she wasn't going to buck the trend of not allowing big tech to be sued. Right. So that's why I've told people legislative change is the only remedy. So they've just been saying a lot of crazy stuff. I think that they should fight back publicly against Rittenhouse with the right case to get public attention, to deter the media from constantly lying about him. But here's one of the problems. Wood sends a letter out saying, look, Joe Biden, your ad suggests that my client was in a militia. I agree that's libel. The problem is John Pierce went on Fox News and Tucker Carlson and compared his client to the militia statute under federal law. So good luck with that defamation strategy now. I mean, they created and compared him to part of the American militia from the Revolutionary era. So they've created their own problem. Like, that would be a factual statement that you could really have. You could probably get past a motion to dismiss with defamation on, that you said he was part of a militia. He's not. Now, it was only by innuendo and by inference. So there's a bunch of hurdles you have to overcome to be able to successfully sue. But the suit they're talking about is not going to go anywhere. And I guarantee you, Biden's campaign was like, so what?
Right. And because, especially when you've got a presidential candidate on the campaign trail, they get sort of an extra layer of protection with the political puffery. Because the judge is going to go, yeah, he's talking in the parlance of politics. He's made a highly public issue, a political issue, and he's not the first guy to do that. So that's going to mitigate anything against Joe Biden outright. And the other thing that I was having trouble with is, what damages are you going to show for Rittenhouse that he's not already suffering? I mean, it's not like he's getting fired. He's sitting in jail. His liberty isn't impacted. His ability to speak isn't further impacted by Joe Biden's words. Right now, you've just got a high-profile guy saying something bad about someone accused of a crime, and not just accused, charged with a crime and sitting in jail without being bailed out. You're going to go nowhere on that.
Well, and that was the other problem, was, like, I would have, if I was representing him, when I sue Wallace, I sue him right away to get public attention on it, to get
Right.
the media's attention. And 3, I focus more limited, that he accused Rittenhouse's motivation of being part of a white supremacist group that committed violence for white supremacist purposes, and there was no factual basis for that. Knowing it's going to be tricky to get past white supremacists as a statement of opinion. Generally, it
Right.
is. You can't sue someone for calling you racist, unfortunately. But willing to take the gamble, see what happens, get the attention, try to back off media members from doing it. That would be the only reason to do it. What he does is he only goes after Biden. He goes after Biden on a weaker factual pattern. And he goes after Biden for things like militia, which his own co-counsel has contaminated. And then the other one he goes after, as you mentioned, he says, hey, this was all self-defense. Well, that right now, you can't sue anybody for saying that Rittenhouse committed murder because they can just cite the probable cause indictment. He's been charged with it.
Right.
So once you've been charged, that's something you really can't get back. It's got to be something unrelated to the charge. So the white supremacist purpose, which was libel, the problem is getting past that being a statement of opinion that's too vague for people to determine. Now, I brought a case that established that you could, under certain circumstances, establish that as defamation for Cassandra Fairbanks. So there's a way to do it, but it's tricky, it's difficult, and Wood's not going to be able to do it. And I don't know who else is with. Now, he brought in Ron Coleman, who's a very skilled lawyer. I'm sure we'll try to help with the case. But my other concern was this. Definitely don't spend money on that. Don't spend the Rittenhouse Defense Fund pursuing a long shot civil defamation suit. Not only that, what happens if you get past discovery? You can't have Rittenhouse sit for depositions while his criminal case is pending.
Right. So, he'll just have to take he'd have to take the fifth on all of his depositions, then they'll draw a negative inference and you'll get dismissed out anyway.
Correct. You have to basically sue and then ask for a stay for suing, which is very. I've actually had success doing that, but it's a very hard thing to do.
Okay, so we've got some chat questions that have come in.
Sure.
I know your time today is limited, so I want to get some of those
Absolutely
out of the way here. So Bad Vibe says, got news. Texas has filed charges against Netflix over cuties, and a bad legal ruling. Minors. And the Cato Institute. He's referencing. So we'll talk about cuties in just a second. Have you seen the article that was put out by Cato Institute about a police officers forcing a minor to masturbate in front of them? So
no,
I read this case and I couldn't believe it. But basically a 17-year-old boy was being charged for sexting his 15-year-old girlfriend, which is one of those. This is one of the problems with those types of laws is they wrap up people in activity that their parents should be discouraging that, but that's not a place for sex offender registries and stuff like that. But anyway, so the police then got a search warrant from a judge to take pictures of the 17-year-old's genitalia, both flaccid and erect. And so,
wow. And so this is actually an argument I have pursued that actually Justice Thomas is with me on, but I wasn't able to get a majority on. Actually came up in the Snipes case, which is my view is the Fifth Amendment should prevent you from being coerced to be a witness against yourself in any form.
Right.
Not just your verbal testimony. This testimonial interpretation of the Fifth Amendment was something that the court created. It did not exist. Historically, the idea was you couldn't be a witness against yourself, period. And that means no compulsory participation in identification lineups, no compulsory handwriting exemplars, which are mental, really not physical anyway. The FBI doesn't have handwriting analysis because of physical test. It's all mental that you're disclosing and what they're looking at in handwriting exemplars. But all of that, which they identify as physical, fingerprints to some degree, my view is you should not be forced to be a witness against yourself, period. And this is a perfect example for it.
Right.
They're using that exception to say, oh, we're just requiring him to reenact something physically. Well, you're going to make mental choices in that process. So that's a problem right away.
Mm-hmm.
But it shows why that exception should not exist in the first place. Being a witness against yourself is being a witness against yourself, whether it's having to be on display physically or having to testify verbally. And both should be constitutionally prohibited from the state's coercive power.
Well, shockingly, he wasn't able to actually, arouse himself is a proper way to say it. And so then the cop threatened his lawyer and said, we will take him to a hospital and give him a forced an injection that will force the erection. And then it blew up, I guess, online. This is back in 2014 that it happened. But he just won on appeal within the past month. The kid did.
Oh, really? Did they say it was a violation of his Fourth or Fifth Amendment rights?
I haven't read the opinion, but I believe it was a due process and self-incrimination. But
the self-incrimination part would be particularly interesting. Right. When they find something outrageous but don't want to expand protection under the Fourth or Fifth Amendment, they'll call it due process because it can be a one-off.
Right. But it's that case was mind-blowing. It's like they're talking about the cop sitting there taking pictures with his cell phone of a minor, and I'm like, yeah, just, you know what, that needs to stop.
Committing the very crime that they're prosecuting him for, theoretically.
Right.
I mean,
exactly. Yeah. Oh, yeah. That cop's phone now has child pornography on it. You know, at the moment he takes the picture, and he solicited the creation of it, which is a separate crime. Okay, so let's talk real quick about Cuties. Obviously, huge social media story. I'm sure you're familiar with it. I'll ask you, although you can plead the fifth if you want. Have you watched Cuties?
I refuse to. I told people in advance I don't like anything like that. I can't deal with because years ago there was someone who was trying to get me to go to the FBI to become a profiler.
No, thank you.
And I was like, while I think I could be very good at that, I said that would drive me insane. I can't stay in the mind of crazy. It's tough enough when I do a trial, when I'm dealing with some witness or someone or the prosecutor or the judge who's just really not a nice person or really evil person. Right. Getting inside their head drives me crazy enough. It exhausts me. It's the way Sean Penn used to describe method acting. And I was like, no way I could stay in that 24/7. That would drive me absolutely nuts. So I can't watch anything like that. When I was representing victims of child abuse and domestic violence, which I know you've represented people in that context. Mm-hmm. It's a brutally difficult work, and sometimes there would be visual stuff, and someone else had to look at it. I was like, I just can't do it. And so so no, I haven't. I'm aware of what's alleged. I've heard contradictory information about what was alleged. There were some people that said there was some semi-nude photo. Other people said it wasn't a semi-nude photo. I don't know if that's accurate, but it does not surprise me that some small conservative counties in Ohio and Texas would prosecute.
Right.
This was going to be coming down the pipeline because they were pushing the envelope. Netflix was taking a big gamble. They got the controversy they wanted to get the attention they wanted, but now there's going to be massive First Amendment challenges to this. But generally speaking, they have to do it inside the criminal proceeding because generally the federal courts say we have to abstain while the criminal proceeding is pending, and we won't get involved. And so, it goes back to the Larry Flint cases, all of that. It's going to come back up. And usually it's going to be a jury question. So, I mean, and I guarantee that juries in those counties, good luck.
Right. So, yeah, well, all they'll have to do is really just play the clips of these little girls gyrating and the camera focusing in on their pelvic areas. And the jury's going to say, where's the rope? We don't need much.
That's going to be the reality. Yeah. Now, I think there are serious First Amendment issues.
Me too.
Because the scope of exactly what can be criminalized and not, and that I always call it the Britney Spears problem. So when Britney Spears was 15, 16, doing those music videos.
Baby One More Time.
Yeah, all that. Exactly. the nature of that was so sort of, it was considered in the constitutionally protected part of that space, even though underage sexual performance is generally not protected by the First Amendment. So usually it's required, like there's a Scalia opinion on this, and basically it was the simulated needed to make the viewer believe it's an actual sexual act, not stimulating a sexual response or imitating a sexual act, but that the actual sexual act is taking place. That's how they've defined simulation within that statute to be, but that's the federal statute. What it is all these state laws, a lot of states, much broader laws. So the question will be, will that interpretation of the federal statute, was that a constitutionally compelled construction of the statute such that it would apply to state law or not? Though I won't be shedding any tears if Netflix loses.
Right. Me either. I do think it's probably protected because what you're going to have to argue is that these clips in isolation go to the prurient interests, and we have to ignore the entire context of the rest of the film. I think that's hard to bring against Netflix. I could see if maybe there was some distributor online that was clipping out these specific things and distributing them to people intentionally. But against Netflix, you do have an hour and a half or 2 hour long movie with comparatively, I don't know, 10, 15 minutes of this activity. It's like, well, what was the rest of it for? You're gonna have to argue that's all a ruse just to deliver the sexualized content. And I don't think that's going to be successful from that respect. But like you said, this is jury trials in small conservative counties. It's very possible that they go, yeah, well, we don't care. And they'll have to then they'll have to appeal it out.
Run it up. Exactly. And I think it's probably good that someone brought a prosecution because it will deter it and clarify the scope of the law.
Mm-hmm. Right. And I think it is a question we need to have. We need to have that discussion. King of Jerusalem sends, love, what are the odds with Barris? And my father loves your show with Viva. Has a question for you. What does he think? What do you think about Oregon electorally this cycle / in the future with all of the violence occurring this year in Portland?
Portland is so to the left that the fact that almost the rest of the state outside of Eugene is conservative, they just don't have enough votes. So it's gonna lean Democrat, state Democrat for the time being. But Portland is just and what we perceive in Portland is different than how Portlanders justify their own behavior. Portlanders are 2/3 of them outside of your Brett Weinstein have no problem with what's taking place. They believe that's why a openly pro-Antifa candidate is likely going to win mayor in Portland. Like, I have a case I'm going to try to take up to the U.S. Supreme Court. It's a long shot, but it's worth it. A guy who got arrested in Portland for just defending himself. Or the Oregon trial court didn't care. Oregon Court of Appeals didn't care. Oregon Supreme Court didn't care. And it gives you an idea of the political dynamics. They imposed an objective definition on self-defense, which is ludicrous. So they said they could exclude. Imagine being in a situation where you're accused of brandishing a gun, in this case.
Right.
And you're not allowed to introduce any evidence about what was going through your mind at the time, about your past experience at the time.
Yeah, no subjective self-defense here, only objective.
Exactly. And a liberal Portland judge is going to decide whether that's reasonable or not, which means they're going to substitute their subjective version for yours when all of your exculpatory testimony has been excluded, including the fact that these same people were part of a group that had previously physically assaulted you in public for doing what you were doing right then, which was filming their protest.
Yeah.
So it's disturbing, but that gives an idea of the political environment. So Portland is so in the mind control of the left. It's so captivated by the left that they're moving further left rather than pushing back.
Sakaki Onsai says, Professor Barnes, welcome to Rekieta's show. Know you from Viva's stream. So, how awesome do you think Trump's doing tonight, calling Pelosi's bluff related to stimulus and other items? Also, do you know Larry Schweikert?
I do know Larry, though he recently blocked me on Twitter because I just pointed out to him that certain assumptions he had about the effectiveness of pre-existing conditions as a political issue for Democrats, at least at the House level, but potentially for the presidential and senatorial level, proved in 2018 to be very effective. He didn't like me. He didn't like hearing that, so he just blocked me. But I like Larry. I still like Larry. So, Larry comes at it from he's more of a partisan. Sure. So he's going to interpret information in a way that's from the Republican partisan perspective. But the useful thing is that he will highlight information that the media is not talking about that is, in fact, helpful, relevant, pertinent information for Trump. In terms of Trump's strategy, there's an internal debate about the wisdom of it. So there's some people that think what's clear is it's very popular to write a bunch of checks right now because of COVID. So there's that wing of the party, and political commentators think Trump should write the check. Others think that the money was mostly going to go to blue states, so it wasn't going to help Trump, and Trump needed to call the bluff of the Democrats that he would refuse to fold. We'll see how it plays out. To me, I don't think it's going to have much of an effect politically adverse to Trump, because not much of the money was going to get in the hands of his voters prior to election day in swing states.
Right.
So but the perception that he's holding it up, it depends on how that plays out. as to, am I not getting relief right now in Pennsylvania and Michigan where I'm locked down because of the president or because of Pelosi?
Now, on a side note, this is my question. Have you seen what's going on in Michigan with Whitmer?
Yeah,
Michigan.
I sued Whitmer.
Oh, okay. So you
Yeah.
sued Whitmer in Michigan.
Yeah, about the lockdown, and she quickly settled my case.
Okay.
So so I didn't get to run it up. Clearly what she's doing, in my view, violates in the internal rules of Michigan, and definitely the whole point of having a legislative branch. I think she's also violating the U.S. Constitution, but it looks like they're going to resuscitate the zombie of Jacobson and Buck and Korematsu and reinstate an emergency exception to the United States Constitution, which is really terrifying. Probably the worst lasting legal effect of this lockdown will be if the Supreme Court green lights that. But if Barrett gets on the bench, I think that's what's going to happen. So I think Whitmer's actions are unconstitutional across the board. It's good that the Michigan Supreme Court recognized she didn't have the power under Michigan law to do what she did. But she's trying to basically, what they said was you couldn't have a long emergency.
Right.
So she decided, I'll just start creating new short-term emergencies, particularly to last right before Election Day. I mean, my view is all these things are going to go away not long after Election Day.
I think that's likely, especially when we've seen death numbers kind of level off. We see infection rates going up, but one of the things that you mentioned earlier was this idea of suing people for intentionally passing on HIV, and that being almost an analog some people are using for COVID. Now, I mean, I have a bunch of kids, and they're in all kinds of activities, and I'm running around signing liability waivers for COVID, and all I can think of is, since when is an activity or a place liable for my child contracting an airborne viral illness?
Correct. And generally, they're just not. Almost all the law in this has been well established for a long time.
Right.
So unless you have something, it has to reach. There's a reason why they had to pass a statute just to cover someone deliberately giving someone HIV. It's because our existing criminal law generally just doesn't reach it.
Right.
So there's certain circumstances where assault and battery, like if you had a doctor deliberately inject you with a disease, okay, that could probably be actionable under criminal law. But anything short of that would not be, because think about what that would do. Everybody carries transmittable diseases around. Nobody takes extraordinary precautions to prevent that transmission. There's all kinds of viruses we have in our body. The flu is a bunch of different forms of viruses that just come back every year, and they happen because people spread it between each other. Imagine if everybody could be criminally prosecuted for that tomorrow. I mean, that's why our legal system will never go down that route.
Right. And what we'd have to do, it seems like, would be to borrow, like, for medical malpractice and develop some sort of standard level of care. But we'd be disseminating that to non-experts to all have this standard level. And it would almost, in effect, create a national mandate, but through the judicial system. And that's terrifying, in my opinion.
And it would give the state extraordinary power, because I always like to remind people, if the court's doing something to you under a private, quote unquote, cause of action, that's still the state power. That's why the First Amendment limits defamation suits, because it's the courts that are instituting a remedy or a punishment. And so the Constitution constrains the courts as much as it does anyone else.
Okay, so I want to transition to a question. I know we're coming up on time here. But I really wanted to ask you about defamation in the age of social media. Sure. You obviously have sued people over defamation on social media, but I've seen several lawyers from my favorite band of wonderful people called #LawTwitter suggest things like defamation can't really exist on Twitter. I've actually seen that argued in court, that basically you can't defame someone via Twitter. What's your opinion on where defamation law is going? Because I don't think they're right personally, but I think there's some evidence to support at least their conclusions about it being effectively dead.
My view is that they're misconstruing a couple of things. In the Section 230 context, there's certain things that apply to even a defamation claim in terms of being able to sue Twitter or any of those, the actual platform. But if an individual makes a false statement of fact, it doesn't matter where they publish it. If they publish it on social media, They publish it by video. They publish it by audio. They publish it by writing. They publish it on a pod. Doesn't matter where they publish it. That is absolutely actionable, and you can sue for them. In fact, almost all my Covington suits are about tweets that are made on Twitter. And even they conceded, the defense lawyers in those cases, because I'm up against all the best defamation law firms in the country, effectively, because I sued so many people. So I gifted myself that.
Yay.
Exactly. I sued big name people. So they hired big name lawyers. Even they admitted that the fact that it was on Twitter did not provide a defense to the substantive defamation claim. Now, what it does is it creates a whole new jurisdiction issue. So it's where can you sue?
Right.
Because my view is, if you make a statement on social media, you're choosing to broadcast that to the whole world. So my view is you could be sued anywhere under due process principles the Supreme Court applied back in the Calder case, New Hampshire, Calder v. New Hampshire, a long time ago. So, but that's going to be one of the new areas of law in the Covington cases, because they're saying, no, you can only sue us where we live, because you don't know where the statement was made, or they just unilaterally claim the statement was made at some place wherever they want to. But by definition, when a tweet occurs, you don't know where they made the tweet from.
Right.
But my view is you're broadcasting that to the world. The point of defamation principles is who is hearing the statement, and not who you where the statement is being made. And what is, they have these old internet cases where somebody says something, and then involuntarily their defamatory statements get broadcast on the internet. And as the person didn't go to the internet to make the statement, it just gets repeated on the internet, and then they get sued for it. In that context, it's unfair for them to be hailed into that foreign court, another state court. But when they decide to go, the fact that they said, you know what, instead of lying to 3 people at the bar, I lied to 300 million people. Now I should not be able to be sued anywhere except at the bar. It's like, I don't think so. That doesn't logically apply. So, and while it creates unique jurisdictional issues, my view is it doesn't matter where you lie, you can be sued, period. And if Law Twitter is claiming otherwise, they're as bad at that as they are at everything else.
I think they're borrowing, was it an old Penthouse magazine case, which was a jurisdictional issue? And I think with defamation, it might not have been Penthouse, but I feel like it might have, where basically, they said they weren't targeting a specific jurisdiction, just by sending a couple magazines there for sale. And so the statements weren't targeted there, so they couldn't be brought into just anywhere. But I don't think that really applies in the same way in Twitter. Nope. Like, because if I lie about one of the Covington kids, for example, I'm not trying to hurt them in the middle of Minnesota. I'm trying to hurt them where they are, in Kentucky. So it's weird thing where you're not intentionally availing yourself of the jurisdiction. Like, you're not saying, hey, Kentucky, you should screw over these kids. But by knowingly defaming these kids, you're attacking them where you are and subjecting them to your to jurisdiction in their place.
Exactly, because my view is nobody requires you to go on social media and broadcast it to the world with the loudest possible microphone. Also, on social media, they can, like in particularly Twitter, they can limit who their followers are who see it. They could limit it. They could even limit it jurisdictionally if they want, in terms of region or location. But when you voluntarily choose the loudest possible microphone, you shouldn't be able to argue, well, because I used the microphone in this place, even though it reached everybody, I suddenly can't be sued except for where I use the microphone. That will create a defamation. That will allow people to libel someone in another place just by hiding out in a jurisdiction that has better laws, or more protective laws for them, that protect more libel. And so that's where I think it's ultimately, I think that part of the Covington case also will probably go up to the Kentucky Supreme Court, maybe the U.S. Supreme Court, part of the reason I took the case, because I think we have a very good argument for making that law clear. Right now, it's all over the place. So it depends on where you're at as to what they say.
There's actually a case in the Western District of Texas, Fifth Circuit, where it's a comic book, an independent comic book creator, and then Mark Waid, who's a famous Marvel writer out in L.A., basically tortiously interfered with a contract in Austin between a guy who lives in Texas and an Austin small publisher, and then he also defamed him both online and in person down in Houston. And his argument on the jurisdictional argument basically boiled down to when I picked up the phone and dialed the landline of the Austin company, I didn't realize I was calling Texas. So therefore I shouldn't be brought into Texas.
Exactly. I mean, what I call it is, in the company case, their argument is because I lied everywhere, I can be sued nowhere.
Right.
And I just don't find that persuasive over time.
Okay, a couple more questions. Well, this one comment is about Legal Eagle. Mithrin Emrys says Legal Eagle devolved from pimping his scam of How to Law School side business while critiquing depictions of the law in movies to pimping his suit sponsor and his How to Law School course and having Trump derangement syndrome.
Yeah.
Very good. Let's briefly, if you can, talk about the McCloskeys, because they are, I guess the big news today is they're indicted on basically brandishing a firearm. And then the other indictment is tampering, which we don't have any real details on, but I assume it's related to Patricia McCloskey's gun, which the DA received and said it was quote unquote disassembled, which just meant it was non-functional. And they reassembled it. What's your perception on the case as a whole? And if you have anything new about the indictments that just came out?
Yeah, I mean, I think it's a heavily political case. I took the Michael Strickland case I was talking about out of Oregon because I was trying to tell people they're going to weaponize the legal system to prevent you from defending yourself. And that's where they're going, and that's where they're directing. So self-defense is going to be a big issue. Gun rights are going to be a big issue. That when they went after this. I mean, Michael Strickland's a little guy. People can look him up on YouTube, laughing at liberals. Little guy just brandished the gun briefly on these people that are big physical guys that had a history of violently assaulting people. This was Portland. Just briefly, and then put his gun away just as he was trained. And he's the one who got prosecuted. Nobody else did, with a bunch of felonies. And then I represent him on appeal, not at the trial court level, and there were issues with what happened at the trial court level. But the mere fact they were going that direction meant that the McCloskeys were coming. Whoever else defended themselves in public, they were going to punish and try to deter anyone else from self-defense. That, especially when you want to defund the police and strip you of your right to self-defense. It's so the mob can have complete power and you can't fight back and nobody's available to fight back. That's the politicized objective. It's like the French Revolution, weaponizing the mob all over again. So in the McCloskey case, so I think it's all political. I don't think any honest prosecutor would bring that case straightforwardly. There's apparently investigators within the St. Louis Police Department who don't agree with bringing the prosecution. It appears that prosecutors have contaminated the case, politically manipulated the case, tried to induce false statements, may have made false statements previously. That may be why they had to go back through the grand jury process. But so I think all of it's political. The clearly under Missouri law, which has very broad, not only castle doctrine self-defense, but broad self-defense, period, all they have to do to brandish the weapon is have any reasonable basis to believe that there was an imminent risk to their property or themselves. And clearly, given both the statements that were recorded at the time, show that was in fact the case. That's what an independent police officer apparently also confirmed. That's what has been subsequently confirmed in terms of what's been released in terms of transcripts and audio. So the idea these guys are either one of them are being prosecuted is crazy. It's purely political. Now, I think the tampering thing is something that bothers me in general, which is the attempt of the state to misinterpret obstruction type statutes.
Right.
Because let's assume the allegation, I haven't seen what the substantive allegation is, but let's assume the allegation is that she did something to the gun prior to them coming in and executing the warrant. How can that be tampering? Tampering is supposed to be with evidence in a case that's already pending. They're trying to make it a crime. I mean, remember, folks, Arthur Anderson knew the next day a subpoena was coming from the SEC, so they went through and shredded. The United States Supreme Court said 9-0, that cannot be obstruction because they hadn't got the subpoena yet. Why is that? Because we don't have an affirmative obligation to help the government screw us.
Right.
We don't have to say, geez, this piece of evidence could be used against me. I better keep it right here. No. Now, once there's a case pending, a subpoena, a civil proceeding, criminal proceeding, and you've been ordered to keep that piece of evidence, then you can't tamper with it. Then you can't destroy it. But the idea that it's your affirmative duty to keep evidence in a perfect or particular way before it even is evidence, before there is any pending case, strikes me as insane. So I suspect they're trying to misinterpret the tampering statute.
Yeah, and from a practical standpoint, of proof beyond a reasonable doubt, how are they going to prove that she tampered with the gun in some substantial way from the time she was holding it to the time they grabbed it? Because my understanding is that disassembled literally just meant that the firing mechanism didn't work because they used it as a prop gun at a trial. That's the statement that they made. So they're going to have to try and overcome that statement with some evidence that'll convince a jury that no, they're lying about that. It actually was assembled and functional. They changed it before we did anything to them. That I just don't know how they're going to get to proving that at all.
Well, and my biggest problem is I don't see how they have a nexus to begin with, so that there was nothing illegal about changing the nature of the gun prior to there being an arrest.
Right.
And
Because
even if people are coming in, let's say the cops are coming in the door and somebody deletes everything on their computer, that's still not tampering. And it has to be seized evidence, physically seized. That's why generally, by the way, you almost never see tampering charges against individuals. That's usually police officers, government agents, somebody that has legal custody of evidence that they're supposed to preserve and protect. I find this a dangerous extrapolation and expansion, and they've been trying to do this on obstruction statutes for 40 years, either the state or the feds. They're always trying to come up with new creative ways to make you basically a servant of the government rather than you be able to protect your own privacy.
Right. Okay, and then one last case I want to ask you if you've heard of.
Sure.
It's a case out in Michigan, and it's a guy named Lucas Gerhard, a kid named Lucas Gerhard. Last year, I think it was about August, he made a Snapchat post, and it had a picture of his AR-15 and some like tactical stuff. And he said, taking this up north to make the snowflakes melt. And by snowflakes, I mean snow. He then proceeded to take the firearm with him up to his college on the Northern Peninsula, checked it into the college armory, which was the procedure, and was arrested immediately afterward for terroristic threats.
Yeah, I mean, that comes under true threats jurisprudence under the U.S. Supreme Court.
Right.
And to give people an idea of what the U.S. Supreme Court said was not a true threat, a guy at a Vietnam War protest rally talked about how he was going to use his sniper and his gun to put LBJ in his sniper view. U.S. Supreme Court said that's not a true threat because it doesn't have an imminent connection to likely violence. There has to be this imminent incitement. There has to be this proximity to the threat, to the supposed threat, and it being actionable. And so the next case, the Ku Klux Klan, Brandenburg, Ohio, does their they say they want to go commit racist violence against the black community right next to them, of them doing the rally. They said that's all legally protected because there was no imminent incitement of likely violence. The Nazi Party decides to go through Skokie, Illinois, which had the highest per capita incidence of Holocaust survivors in America, decided to march through there. They said that march couldn't be prohibited because there was no imminent risk of imminent violence, even though they were cheering on the Holocaust.
Right.
So in that context, what they try to expand this all the time. They're trying to do it against Alex Jones in a Connecticut case, where they're saying that just complaining about a lawyer now is grounds to call something a true threat. So it's just insanity where they're always trying to protect the state and make it impossible for you as an individual to express yourself politically if it has certain language in it. But unless there's imminent incitement, then the First Amendment protects that speech. So terroristic threats has to be likely actionable for it to has that imminent incitement or likely to occur. And unless both are usually present, it usually doesn't pass First Amendment scrutiny.
Now, I agree fully. I did a terroristic threat case locally in Minnesota. They just tend to charge it to try and get you to plea down.
Of course. That's always what it is.
But in Lucas's case, he was arrested, held without trial, without bail for 82 days. And then since then, he is still on house arrest. It's been over a year. He's on house arrest. And at one of his hearings, when they asked to get the ankle bracelet off, the prosecutor actually played the footage of the Christchurch shooting from New Zealand. And the judge said, "Nope, you're staying on." It's like, wait.
Wow. and those kind of cases, you have to start raising the constitutional defenses right away. You have to start attacking the system right away, the political motivation right away, because if you get behind the 8 ball, then the problem is you're not ahead of the curve,
Right.
and things get out of hand, and they're just so accustomed to violating people's rights. I remember first time I was in a juvenile court, and I started raising constitutional issues. And the judge looked at me in Tennessee. He was like, "Constitution? What Constitution?"
What's that thing?
Apparently, no one had ever thought about raising that in juvenile court, even though you're dealing with family attachment issues that go right to core constitutional issues. So that's it's unfortunate, but it's too commonplace.
Okay, I have one more for you, and you'll have to forgive me. I'm requested to do this in a specific voice.
Okay.
So it says, Barnes, if Rittenhouse wants to get you to sue Linwood and take over his defense, would you do it? Why are you smiling, and what's that thing on your face?
So, I think hopefully the goal will be that the funds somehow get released back to Rittenhouse. I'm not real hopeful. Maybe they're correcting some stuff. They do have a state Wisconsin lawyer. They do have Ron Coleman involved. So maybe it will get better and it won't be the disaster that I am concerned with. But there's a bunch of lawyers willing to help out. So if the money could get released back to the family, the hard part is once there's a client-lawyer relationship, I as a lawyer can't talk to that client.
Yep.
And that's my other concern is it's an area where I've actually never been in favor of that. I've been in favor of the anti-contact rule for the government because I think that's part of Sixth Amendment right to counsel, which, by the way, they violate all the time. They try to defend a company and they find 100 excuses to get around talking to you, or they get your client arrested and then they plant. That's the problem with Rittenhouse. I mean, he's a kid who's never been through the criminal justice system.
Right.
And sitting in a jail, they're going to be putting people next to him, guaranteed, especially up there in Kenosha with the political pressure on this case. Once they made the highly, as you noted, the indictment reads like, why are you indicting?
Right.
And yet they're continuing to, and the prosecutor there has assigned high profile top people in his office to prosecute the case. So they know they stick Rittenhouse in jail and I guarantee you, they look at a guy like John Pierce as a joke. They look at Linwood as a joke. Nobody's intimidated by them up there. And so that's the problem. That's why you had to bring in a powerful team with not only a national reputation, but a local reputation. And that's why Wisconsin lawyers are reaching out to me saying, look, we can do a great job on this. We're willing to work for dirt cheap on this, but we're not willing to work with these guys. So will you publicly talk about this? And I said, fine, I will. But unfortunately, they sort of got a lock on it, and people are buying into the hyperbole. It's like the way the left people defended Avenatti. You're seeing the right defend Linwood and defend John Pierce.
Right.
And they don't really want to hear the negative. They want to imagine everything's great. They still think that the salmon case went for hundreds of millions, things like that. So this case is totally different anyway. It's a criminal case in Wisconsin, not a defamation case that Wood has done a lot of.
Right. What do you think about crowdfunding lawsuits? I mean, it's a growing trend. Obviously, any major lawsuits are going to have huge crowdfunding implications. I think there's some risks involved, but I'm also, what you mentioned before about the small d democratizing the legal process. It offers an avenue for real injustice to be addressed. So what do you think about kind of the overall aspect of it?
Well, there's 3 aspects to that. One is, at the request of other people, I helped start a group called Free America Law Center.
Sure.
And the goal was to create, a subscription-based model. So this gives you an example of what I think can work. I thought, okay, you need a mass volume of support. You need it to be bigger than one lawyer, ideally last longer, something like ACLU, except a small enough subscription amount that what's really fuel is that so that you're not dependent on any small group or one person or donor.
Sure.
Because that's what happens with all these legal organizations. They get taken over by one or two groups that really control the case in disparate ways. Make it independent of a law firm, so that way it's an organized group to help fund various litigation or legal expenses related to cases that otherwise there isn't a market. The marketplace of the law doesn't provide protection for, that there isn't financial incentives to take a lot of cases that are justice-oriented cases.
Right.
Only in the civil rights arena or the personal injury arena does that work. Defamation doesn't work that well. Other areas, big trying to go after or remedy big tech problems. Tough as well. So, and then some selective criminal defense cases like this have shown the need for it. So I'm in favor of some mechanism of it. I did the free America. I think that model is one that would be the best for people to recreate where they can. Because the problem is, if the money goes directly to the lawyer, to the law firm's trust account, there's all, as you know, ethical issues, quagmires, because you've got to make sure everybody signs waivers, that they realize that they're funding you doesn't give them any right or control over the fundamental substance of the case. You have the client basically being beholden to their funders. So it can create, that's where my view is, in the criminal arena on a case-by-case basis, outside of something like the Free America Law Center model, it would be get the money to the family so that they have control, they have power, they have authority. That's also cleaner, that's also neater. Plus you avoid the build the wall problems. So like you look at what, it's amazing now that they're starting to criminalize fundraising, which I mean, in Build the Wall, there wasn't a single person who donated who complained. They brought a criminal prosecution without anybody complaining about what their money was going for.
Right.
They basically overpromised. I mean, they promised more than anybody reasonably could do. Nobody had a problem with a triple amputee getting a little bit of money for this effort that raised more money than anyone ever thought, when it was way below the normal administrative cost for a comparable fundraiser. But they're facing 8 to 10 years in federal prison. So yeah, I would also, it's always recommend to people, raise it for the family, and the family should keep it broad. In other words, don't say this is only for legal defense.
Right.
Say this is to support us, including legal fees while this is going on. So like I thought Rittenhouse's mom could have done a GoFundMe without connecting it explicitly to her son or the thing, saying and then other people could link and say, support Kyle Rittenhouse, give to his mom. GoFundMe would have had a problem taking that down.
Sure. Yeah. And I think that's an interesting way to do it. As far as the waivers go, I think it's a little bit, it's weird with GoFundMe, right? Because you've got basically anonymous donations.
Yes.
A lot of times these people don't have any contact with the fundraiser. Like, for example, I think I mentioned before the show, I set up a GoFundMe for a guy who ended up doing a defamation lawsuit. And so I directed all of the money to his firm's IOLTA account. And so it's held in trust for his benefit. And the part of that was kind of a legal strategy on the attackability of the money. Because I figured if they just sent it to him, maybe they'd be able to try and get, go after it or something like that. But the other interesting thing for me was the people donating will have no influence over the fund at all or how the funds are spent. And there's no interference with the attorney-client relationship because they're talking to me. I'm directing it to whoever he hires.
Right.
And so
in that case, effectively, you're funding it. In other words, your source of it was a range of people,
Right.
but you're effectively funding it from an ethical perspective. So if you're in the lawyer's position, all you need is for you to know that you giving that money doesn't give you any control over the client's case.
Right. Right. And dear Christ, I wouldn't want any.
No, most people wouldn't. It's just that now that they're trying to criminalize everything and find, make everything a problem, it's just the way fundraising is done has to be careful.
Right.
Particularly if you're on the quote unquote wrong political side.
Yes, I think that's a big thing. Well, sir, I have kept you a little bit longer. So you are welcome to leave at your leisure. I really do appreciate you coming on the show. If you want to hang around longer, there's tons of chats for me to read through, but I tried to hit the main ones that were directed at you. But you're certainly welcome to stay. I'm not kicking you off, but I also want to respect your time. So.
Oh yeah. I probably do have to hop off here, but yeah, it was great. And we'll do it again.
Yeah, absolutely. All right, man. Thanks for calling in. Have a good one.
Yep. You too.
Peace. Okay, guys, that was a Mr. Robert Barnes. That was Mr. Robert Barnes, and really a fantastic guest. I really enjoyed having him on. Would love to have him on again. I've never gotten to actually speak with him, but tons of experience, Very good conversationalist. I liked that segment a lot. So hopefully in the future we'll be able to set up another one, and and get some more topics and see what other stuff he's gotten up to. Twisted Man, I've had Viva on the show. The hardest part about getting Viva on my show is the time. It's very late in the day for Viva to come on the show. We talked about that the last time he was on. I think we may have even done it at a special time. I can't remember. But if we did it at the normal time, it was truncated because it's such a late show for him. So it was good. Good conversation. Good subjects that we have going on. Good blasts at Pope Hat and Law Twitter. That's honestly all I came for today. So we can shut this down and go home. Mario Carter, I'd go on Viva's show, absolutely, but I don't impose myself on other people's show. If he reached out and invited me, I'd be happy to do that. So here's the thing, guys. Normally, I talk a lot more, but I knew that my time with Barnes was short, and I wanted to let him talk as much as possible and to share his knowledge and his experience with us. As a result of that, I drank more beverages than normal, and I have to go to the bathroom. Okay? So give me just a minute. I have to go to the bathroom. I'll come back. We'll cover some more subjects, and then we'll wrap up the show. We're probably going to end up having a little bit of a shorter show today than normal, but that's okay. Or we may not. We may not as well. But let me go to the bathroom. I'll be right back. Chair Kun, please take over. I'll see you guys in just a second. All right. Oh, boy. Woo! How are you guys doing today? Oh, my goodness. So that was, I know that many of you might have missed the very beginning of the stream, because I normally take a while to get started, but we had to get right into it with Robert. So I do thank you for indulging me. If you happen to miss that segment or the beginning segment, go back and watch it on the replay. Speaking of replays, there was a brief issue with my live stream yesterday being replayed. There's a brief issue with that, and that was that even though My Room Records composed the music for Goodbye RBG, cancer in the end, that it was claimed by BGM Music. They copyright claimed it. They said it was theirs. And so I muted it. I hit the mute button, and YouTube went in and muted out the song. So that's why it happened that way. So it shouldn't be. It shouldn't be that way. And so I may play it again tonight. And then challenge it. I wasn't sure, but I talked to My Room Records, and he sent me a message and said that he composed all of the music himself. So I might play it again and then challenge it and send them a profanity laden statement about it, because that's fun. It's fun to swear at giant companies and know that some jackass lawyer has to read it somewhere. So Angry Baneling, it was BMG, Sony, I believe, BMG, if I remember right, was the one who claimed it. So anyway, that's who it was, and it was probably done by an algorithm. So it was a Content ID claim, and here's how Content ID works: is there's an algorithm that matches up a percentage of some footage with a percentage of something else, and then it takes those two things and it compares them, and it gives them like there's 100% match if you play like a direct video from a Content ID creator on YouTube. Like if I go to Vivo Music and I just play like a Britney Spears video straight through, it's going to have 100% match. And so they'll know that was just the full broadcast of their thing. If it's less than that, it scales down percentage wise. I don't know what percentage it said was theirs, but I imagine that it picked up on, even though his background music was composed differently, his vocal melody was the same. Or very similar. I shouldn't say the same, but it was very similar. Different key and everything, but still same basic note progressions. So I'm guessing it got that. The AI is getting too smart. The AI is getting too smart, and it's able to do that. What? Like a little fuzzy on my cheek that I can see out of my eye. It's driving me crazy. So anyway, Curtis, he probably has figured it out after 3 years. Lots of, newer creators don't understand that stuff as well. And so that's how it goes. All right. Tonight, after this show, we are going to go over on Twitch, and we're going to watch, the show's not ending yet, but I didn't get to lay this out at the beginning of the show. We're going to watch John Carpenter's Vampires tonight on Twitch, and then we'll follow that up with some other movie afterwards. It'll be fun. Probably Sleepaway Camp 2. So that's the idea for tonight. It's going to be a blast. All right. So if you haven't caught a watch party on Twitch and you are up late, come over and watch. They're so much fun. And watching James Woods kick a priest's ass and then ask him if it gave him a boner that's good. That's premium stuff. Okay, there's been an update. Ryan Haywood has left Rooster Teeth. I hope you guys have seen this. Ryan Haywood has left Rooster Teeth in shame, and he's begging people to stop sending quote unquote threats to his family members. For some reason, I'm doubting that anyone was threatening his family members, but maybe they're like, yeah, you awful, catch you next Tuesday. How dare you make Ryan send nude pictures to someone who's not you? Yeah, you should be in trouble and hurt or whatever. So anyway, I don't buy that part of the story that his family was receiving threats, but it's the internet, so maybe they were. I don't know. You know what? There should be an internet law, a rule of the internet. If you ever come out with some statement that says, my so-and-so or me received a threat, your computer AI should automatically grab what you labeled the threat and post it right there for the entire world to see, because that needs to happen. We need verification. I want to know how many fingers they said they were going to cut off, and if they just said, you know, you've got a tiny penis and you shouldn't have posted it online, maybe you didn't get a threat. Maybe that's not what happened. All right? Maybe actually people were just making fun of the fact that you seem to like taking videos of yourself jerking off, you giant weirdo. Maybe that's it. Maybe that's it. I don't know. I wasn't there, and I didn't send anybody anything. But I just have a feeling that when someone says, please stop sending threats to my family, that they're not a serious person and that there wasn't a serious threat. So, I'm not actually commenting on the size of anything. I'm saying that would be a comment that someone might send. You know, that's what I'm talking about. Okay. That's a funny thing that's been going on. Let's talk about cuties, shall we? Let's talk about cuties and Netflix. I think, is that what I'm looking for? Where did it go? Oh my goodness. Oh my goodness. I don't have this set up. Let's pull this indictment up. Oh, Jesus. I can't even show this. It's got pictures from cuties. Can I find this, please? Good job, Fox. Thanks. I'll just show you. Okay. Get this pulled up. I'm so excited, guys. I ordered a new Wi-Fi setup for my house. I ordered a mesh Wi-Fi setup. I have like a cobbled together mesh Wi-Fi setup, but it's not made that way. And so there's some and my router's old. And so I think there's some issues with like actually having it work in the way it's supposed to. But so I'm really excited for the real mesh Wi-Fi solution. I can't wait for that. Coming to my house on Thursday. Whew. Speaking of Friday, which has nothing to do with what I just said, Uncivil Law, who is mentioned by Barnes here, will be on Friday. That is on the docket, so to speak. This week, we had Barnes Law today. We have Uncivil Law on Friday. Zypher Warrior, I got the... See, I don't even want to say it. I don't even want to say it because I'm going to get death threats. I'm going to get death threats over my choice of technology because I always do. You guys always make fun of me. But I got the Orbi Wireless 6 Mesh Wi-Fi or Wi-Fi 6 or whatever. The Mesh Wi-Fi one, the Orbi one. I got that. So it's very highly rated for bigger spaces. Excalibur, my house is not small, and the other problem is there are spaces. One of the problems is where the cable signal comes into my house is on one end of it. It's actually here by me, but it's on the other side of the vault walls, which is why I had to have a hole drilled through the vault to get a hard line into the office, because Wi-Fi in here is really spotty. But it's here on this side of the house. Well, there's a whole other side of the house, and more importantly, upstairs in my bathroom, which is across the house where I poop, that has spotty Wi-Fi because I've got the Wi-Fi here, and then the mesh range extenders, which, like I said, aren't working very well. That is, and that's critical time. Sitting down on the toilet is when you need the best Wi-Fi there is. But yeah, so it's that, and then also Lady Rackets does a lot of work out in our garage, and it's the signal out there gets really weak and stuff like that. So I got the Orbi system, which is like, it's got, from all the reviews I read, it's like the most powerful over distance and stuff like that. So it should be good. It should be good. I'm very excited for it. Anyway, this is unrelated to anything. I'm just chatting with you guys because I love you all, even when you make fun of my tech choices. Here we go. Netflix indicted by Texas grand jury for Cuties film. I know I don't have the full headline up there, but I didn't want to like mess with the zoom when we got it. Don't look at the pictures. Oh God, I can't even get rid of the promotional poster. Netflix has been indicted on a criminal charge that alleges the streaming giant promotes lewd visual material of a child. The lawsuit centers on the release of the French film Cuties that has been mired by controversy since its release last month. A Tyler County, Texas. Now, Tyler County is not the same as Tyler, Texas. Ty Beard is from Tyler, Texas. Tyler County is not Tyler, Texas. Tyler is in Smith County. Also was one of the last dry counties in Texas, and only recently started being able to sell alcohol, and still doesn't really have any liquor stores. So, lewd visual material of a child. Lawsuit centers on the release of the French film Cuties, has been mired by controversy since its release last month. A Tyler County, Texas grand jury moved to return an indictment against Netflix on September 23rd, Fox News confirmed on Tuesday via court documents. The complaint alleges Netflix knowingly promoted visual material which depicts the lewd exhibition of the genitals or pubic area of a clothed or partially clothed child who is younger than 18 years of age at the time the visual material was created. So here you go, guys. This is a statute that's actually on point with this. They're saying that we get that they're wearing clothes. However, the depiction itself is lewd, and it's a lewd exhibition of the pubic area. So you can try not to, but you can picture, well, let's picture it on adult women, right? So if you're perusing Instagram and you just type thought in, you will see lots of something called scientifically referred to as camel toe, right? That would be, now if there were just pictures zoomed in of camel toe of an Instagram thought, that could be a lewd exhibition of genital area or pubic or pelvic area that is similarly clothed. Okay, so that is how this works. For example, that's not the only way, but that's an example I can give you. All right. So, I don't think that's the case in Cuties. I think it's more about the camera work. If you've seen any of the clips online that people are disturbed by, it's the focus on the pelvic region of these young girls and zooming in on the camera on the action that the allegation is that this is intended to elicit sexual response. And so here we do have an on-point statute, though. And so I want to point that out. This is not about having nude. That would be a different statute entirely. A different criminal act would be if the children were nude. They are not nude, and there's no allegation about that, and that's not a hurdle they'll have to overcome. What they'll have to do is say that this is protected First Amendment speech. That's really hard to do. It's really hard to do in the criminal context. It has to be done in a very specific way. And pretty soon, I'm probably going to introduce you guys to a case, a Supreme Court, Court of Appeals case, I believe, that was brought to my attention, and it is about Lolly and someone who was actually convicted for basically, what is it? Lolly Shimonetta. Is that the right word? Shimonetta, I think, was included as well. And someone who was actually convicted of crimes for it. Now, there's a lot that goes into that conviction. It's not just, oh, they had it, therefore they're in prison. It's not that simple. So before you get too worried about it, for those of you who are fans of Lolly, and I would urge you to stop being fans of Lolly if you are, but of course I'm talking about sexualized. Okay, all the caveats, all right? But there is a case out there where someone was convicted and that was upheld on appeal. That's because state law convictions in criminal court don't have the same, and Barnes was talking about this, they don't have the same sort of method of protecting you that you would have in other contexts, especially in federal court. So Shota, not Shimonetta, Shotokan. Yes, Lolicon, Shotokan were part of this guy's searches. Now, again, that case is very specific and very interesting, actually, and that's why I'm probably going to cover it soon. But I'm kind of thinking of launching a Patreon-only podcast, Patreon Subscribe-Star only podcast to cover these sort of cases. And maybe we'll be like Degenerate Law or something, and be like a once a month or twice a month sort of podcast that would be out, that would be exclusive. I've been trying to figure out how I want to do that. But yeah, so there's that case. There are other cases out there. I'm trying to add value to those subscription services for the subscribers who are out there as well, without adding cost. I don't want to add cost to people who support me or anything like that. But if people want like this specific content and people who do support me, I want to provide value for that. So yeah. But anyway, I'm bringing this up, one, to low-key shill for something I haven't even done yet, and two, to point out that you can get convicted for things that we might otherwise think are probably protected. Like, I still think even the most degenerate and horrifying lolicon should be protected First Amendment speech. Again, I don't think it should be made. I don't think you should look at it or whatever. That's up to you to deal with. But I do think it should be probably protected First Amendment speech. I don't see any children being harmed, and I'm not entirely sure I buy the argument without data that Lolly is some sort of gateway to harm. Now, if someone presents me a lot of data on that, I might change my mind. But right now, I haven't seen it. So my initial thoughts on Lolly and on Cuties is that I think it's Cuties especially, I think is horrifying. I think there is actually harm to these girls. I think it's abusive and exploitative of them. However, I do think it probably still falls into that First Amendment protected speech. But this case is going to make an interesting point that it's not. That it's not protected First Amendment speech. Now, I don't know if the district attorney in Tyler County is a particularly skilled attorney. Who knows if this case is even going to be argued very well. It's definitely going to get appealed because you've got Netflix. They're going to appeal the case, most likely up to the appellate and even the Supreme Court level. It has a real possibility of getting there in like 5 years. And it's a big question that we have to resolve legally is how far do we let First Amendment protections go? Or more appropriately, how far are we willing to abrogate our First Amendment protections for what we would consider common sensibility? And the thing that really scares me about this is that, thing that really, really scares me about it is that, how do I word this? What the public sees is sensible now, where we saw a big public backlash against Cuties from a lot of people on a lot of different sides. Give it 5 years. Give it 5 more years of indoctrination, of agendized sort of marketing, and see if Cuties is offensive to people in 5 years. My bet is on it won't be. I think it should be. But that's a big question that has to be resolved in that First Amendment context as well. Is, look, Cuties might be offensive now, but in 5 years, if it's not, then what happens? How do we undo this monster that we've built? And that's why I tend to fall on the side of the First Amendment protection. So, yeah, it's a complicated case. But here, let's keep reading on. The complaint alleges, oh shit. Oh wait, I forgot to read the rest. Clothed or partially clothed child who is younger than 18 years of age at the time the visual material was created, which appeals to the prurient interest in sex and has no serious literary, artistic, political, or scientific value. Okay, so here we got to get to the things that are going to be really hard for them to prove in theory. Now, in a small town Texas jury, maybe not so hard, but theoretically, when this gets to the appeals court and potentially the Supreme Court, this is where it gets hard to make these arguments. Prurient interest in sex is like how do I describe it? As an almost universal or unmistakable arousal. Like it's intended to cause and elicit sexual responses. It's not intended for other purposes, is what they're saying. So, anyway, it has no other purpose to it. It's only intended to elicit that sexualized response. That's one part, or not even intended, but it only does. Okay, that's one part of it. The other part of it is there any serious literary, artistic, political, or scientific value? If there is, it's a balance. And they have to determine whether the value, and it doesn't have to be much at all, outweighs, I should say, the prurient interest in sex. So, if you've got artistic value in Cuties, and according to the court, I think you do. Literary and artistic value. You've got a full film that's happened, and most of the film is not these particular scenes that are disturbing. So that's another problem they've got. Netflix has previously defended the film in statements to Fox News, calling the project a powerful story about the pressure young girls face on social media and from society more generally growing up. Media giant doubled down on Tuesday. Quote, Cuties is a social commentary against the sexualization of young children, a spokesperson for Netflix told Fox News. This charge is without merit and we stand by the film. All right. Funny because they're being forced to defend it even further. However, if I give children heroin, hypothetically, and I have them inject heroin on film, and start frothing at the mouth and overdosing or whatever it is that they may do, to spread as a social commentary against the dangers of heroin to children, like, I haven't really done a service to anybody, and that doesn't automatically make it of value. Okay? So let's calm down there, Netflix. Just because, like, you can make a pornographic film that is just hardcore pornography, that is depraved and disgusting, like Lizzo getting banged by Boogie or something, right? You've got that, and it would just be absolutely horrifying to anybody watch, and it will, kill erections everywhere or whatever it is, and it can be about the dangers of pornography and what it does to people. That doesn't make it like noble or automatically good that you made it. You can still do something terrible for humanity in the name of being a commentary against something else. Like if I burn down a building and say I'm against the dangers of fire, this building burning down that you all love being on fire, that should teach you that fire is bad. It's not useful to society. It's not helpful in any way. You've just burned down a building and tried to cover it up. Catch you later, Bob the Troll King. Sorry, buddy. I was just trying to give you a good analogy. All right. Meanwhile, Cuties writer and director, French-Senegalese filmmaker Maimouna Doucouré also previously penned an op-ed for the Washington Post. In it, she wrote, "We as adults have not given children the tools to grow up healthy in our society." So you're going to make cuties? Like, that doesn't make sense. Film tells the coming-of-age story of an 11-year-old Senegalese girl as she discovers her maturing self, all while looking for acceptance in her religious family and a group of young dancers she hopes to befriend. Here we go. So here is the, well, let's, all right, so here's the statement released by the Tyler County District Attorney's Office. On September 23rd, 2020, a Tyler County grand jury indicted Netflix for promotion of lewd visual material depicting a child. Indictment stems from the promotion of the film Cuties in Tyler County, Texas. The summons was served on the corporation on October 1st by the Texas Rangers, not the baseball team. These are the actual ones who do police work. Section 43.262 of the Texas Penal Code says it is illegal to knowingly promote visual material that depicts the lewd exhibition of the genitals or pubic area, blah, 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 blah. The offense is a state jail felony. Criminal District Attorney Lucas Babin said of the indictment, "As a district attorney, I have to sift through countless cases and make calls every day on how to keep our community safe." I thought he said communists. Communists safe, but he said communities. In our county, it is not uncommon for me to confront cases with underage victims. After hearing about the movie Cuties and watching it, I knew there was probable cause to believe it was criminal under Section 43.262 of the Texas Penal Code. The legislatures of this state believed promoting certain lewd material of children has destructive consequences. Such material is distributed on a grand scale. Isn't the need to prosecute more, not less? A grand jury in Tyler County found probable cause for this felony, and my job is to uphold the laws of this state and see that justice is done. Prosecutors of the Tyler County Criminal District Attorney's Office are subject to rules which limit their ability to make public comments about pending cases and the defendants in those cases. This office will not comment on the merits of this case. All defendants are presumed innocent until proven guilty. So there we go. That is the statement from Lucas Babin. Movie sparked backlash. Blah blah blah. In a statement to Fox News last month, the Parents Television Council called for President Trump and the Department of Justice to probe Netflix about Cuties and for its alleged pattern of behavior. Please don't probe anyone. I'm trying to prevent the probing. We're ultimately asking the president to instruct the DOJ to investigate Netflix not just for this film, but for its pattern of behavior, said Melissa Henson, program director of the Parents Television Council, a nonpartisan education organization advocating responsible entertainment. I hate them already. Just because I don't like Cuties doesn't mean I do like these people. Don't fall into this trap. Don't fall into the trap. Okay? Don't fall into the trap of liking these ratings and censorship boards. They're awful. They're terrible. Terrible. Really awful. Awful people. We hope to get Netflix to be more responsible and refrain from sexualizing kids for entertainment going forward. Yeah, me too, but I don't like you guys. All right. We got to. So that's the story on Cuties. This will be a really interesting case to follow because, like I said, it's really, according to the vast majority of jurisprudence out there, this should be protected First Amendment speech. But it really is offensive, exploitative, and I think, personally, it's damaging to the children. So, yeah, so that's a mess there. What else was I going to talk about? Oh yeah, I read a case today, and again, this is a shameless promotion of the podcast that doesn't exist. I read a case today that was about an old Texas case, and it was about banning sex toys. And I put a quote of it up on Twitter. Did you guys see that quote? God, it was beautiful. That was from the case. That's in a document. Here, hold on, I'm finding it. So here's the quote. The state proposes a different right for plaintiffs. The right to stimulate one's genitals for non-medical purposes related to procreation or outside of an interpersonal relationship. Wait, what? Oh my goodness. So the state is proposing that people have the right to self-stimulate their genitalia. So there you go. There's all sorts of gems out there on this stuff. That was a pretty interesting quote to just see randomly as I'm reading through cases. I wanted to take one more look at this cuties thing. I was going to pull up, let me see if I can pull up the actual law about it and see if there's any quick stuff we can see about the decision. All right. I don't want to be in Minnesota. We got to be in Texas. Okay, we've got Texas Penal Code. And we've got 43.262. That. Okay. Let's see if we can get some decisions. There's no decisions on this. All right. There are 4 citing references, 1 case. Why is this cited in here? The DWI case. Very weird. Let me see if I can find this. Let's see. 43.262. What footnote is this? We observe that the phrase, if it is shown on the trial of these numerous provisions that raise the degree of the offense, some based on prior convictions. Okay, not important, not related to it. All right, so I'll show you guys what I'm looking at here. Here's the law. Whoops. Let me shrink this down for us. All right, so here's the law itself, 43.262. It's section B1. There's no if you look up here, there's no notes of decisions. There are no decisions. There is no case law about this. So there isn't a case which will guide us on how the court might interpret it. That's probably bad for Netflix. That's probably a bad thing for Netflix, to not have any case law out there. They won't have anything narrowing or clarifying any of these rulings. So that's that. I just wanted to check while we were here and talking about it. But you know, like I said, it'll be an interesting case. I'll see if I can follow along with it. I assume it's going to get some news coverage, but it's all right, we got some. There's a couple chats that came in. And I will have to get, actually, there were a bunch of chats that I had to skip during Barnes. as well. Kalinka Pavlova says that's so stupid about the Snapchat kid. Here, a judge let a violent crime go to a criminal go to a tangi, Maori. I know I said it wrong. Memorial service for a day, and surprise, surprise, he didn't come back to prison. You know what? I had a client whose cousin, who was also like his good friend, killed himself. And my client was in jail over some nonsense. And I tried to get him to be able to go to the funeral, like even under my own personal care, for like, 2 hours to go to the funeral, and they wouldn't let him go. It was really annoying. Can I help you get your Twitter account from suspension? My Twitter account's still suspended, so no, I can't, unfortunately. I wish. If I knew how to fix yours, I might know how to fix mine. JXDBX says, good lawyers, sir. You're the first person to give me a good reason not to support ACB as our next Supreme Justice. Yep, Barnes has been a vocal critic of her. As far as Trump goes, she kind of fits right in. Not just because of the women issue and making her immune to like a random sexual assault claim that was going to come out if he had appointed a man, but she's a state control authoritarian on many issues, not so strong on the personal liberty front. This isn't a criticism of Trump, but it's an observation that most of the language he uses in talking about things is really from that sort of authoritarian right sort of perspective. So in that vein, she kind of fits in with who she is. There's no voting, Bainling. No voting on that by us, just by legislatures. Senators. Bad Vibe says, wait, a father of 5 that isn't crazy. This is going to be a short drive. And also, I might argue the first doesn't apply under financial considerations of compelled expression, and consent by parent is a fact question, in my opinion. Are you talking about the cutie stuff? I'm not sure what compelled expression you're talking about. Because it's not about... Oh, you're saying that the girls are compelled to express in this way, so therefore it's not First Amendment protection. Yeah, you're not gonna, that's not gonna go very far. In my opinion. Bad Vibes also says, great, the late Nick Rekieta has risen from the closet. The Uber driver is a necromancer. And Bo Stoker says, yo, Anomaly is going to be getting shut down by Facebook. He's looking for a lawyer to help. He believes he has enough proof that it's slanderous and malicious enough to sue. Figured you might be able to help. Who's Anomaly? I don't know who that is. Ryan Mercado asks Barnes, Nikki, how would you guys accurately describe Rittenhouse's current legal team? The only reason I didn't read this, Ryan, is because Barnes was in the process of doing it when it came in, or when I saw it at least. So he was already going through that already. Let's see, what else is there? I saw one over here. Ptolemy Mike says, hi, Nick. Glad you mentioned that you keep more of your shekels if you get them via Streamlabs. The best grifting is efficient grifting. Yes, thank you. That is true. All right, guys. I think what I should do is go ahead and read the rest of the chats, and then we'll go over to Twitch. How can we get term limits for Supreme Court and Congress? You won't. Constitutional amendment. I mean, it's how you do it. You're not going to get it. They won't limit their power. They won't do it. When have you known Congress to limit their power? It never happens. Raven Z Black, they didn't actually claim it was for young girls. They just claimed it's about the struggles young girls face. So telling old people who went through those struggles, I guess, is very necessary. Or something. But yeah. So Diamond Duck, we'll see. I don't know. Crusader Saracen. Okay, like I said, I'm going to go through Justice Chats and Super Chats. We'll wrap up the show. And we'll have, and then we'll go over to Twitch. Tomorrow, I'm not positive what the show topic's going to be yet, so stay tuned for that. There's some things brewing. There's some things brewing that I would love to talk about. Sorry, Diamond Duck, that's the answer I can give you. Crusader Saracen says, I'd call Legal Eagle a tool, but tools are supposed to be useful. Knight of Hopex says, buddy, the days of Democrats being for the union man and the little guy and passively hating religious values are over. They've moved on to open out Marxist revolution. Don't know if there's any value in being with the left as a freedom person anymore. You must be talking to Barnes. He said he was a small D. He didn't even say he was a small D Democrat. He said he believed in the small D democratic distribution of education, of knowledge, I should say, not of education. He was talking about democratizing the practice of law and the knowledge about the law. He's talking about shows like this. He's talking about shows like Viva Frey and him, who try and just help people learn stuff. He's not talking about being a Democrat. I think you'll find Robert Barnes is probably not a Democrat. Z-Star, I would love to get Mark Kern on. David Harris, the vice presidential debate. That's coming up, right? When is that? Vice presidential debate Wednesday. Wait, that's today. That's today at 8 p.m. Central. God damn it. I haven't talked to Ty. I thought we would. Yeah, it's tomorrow. Today, it's after midnight where I am, so today is what I was saying. I thought that Ty and I would do that. I also had talked to Q about doing that because I think Q is doing it on Out of the Darkness as well. I had talked about potentially doing a show where like Q and I each broadcast to our own channels, but we're on together, if that makes sense. I don't know. I don't know how we're going to do it. I didn't realize it was on tomorrow. So I'll let you know. The short answer I want to say is yes. I would love to do it. Just do you and Ty? Maybe. That may be what we do just because that's what we did before. So we'll see. We'll see. I'll announce it as soon as I figure that out tomorrow. Like I said, I haven't talked to Ty since almost since the last debate. I think it would be great. It'd be great. We had a lot of fun last time. I would love to do it again. All right. Mercenary X says, you are wrong. QAnon is real. The problem is that Q has to lie, because if we can see what he posts on a public forum, so can Trump's enemies who want to see Trump dead, then the rest of us. Future proves past after all, and a lot he has said has come to pass. Think. Josh says, the uncivil law Twitter thread was crass pretentiousness and snobbery on steroids. The icing on the cake was the high priest of law Twitter backtracking by saying he didn't think uncivil law would find it, as if Twitter isn't a public platform. Wait, did these guys rip on uncivil law? What for? What are they shitting on him for? That guy's always cut it pretty fair as far as I can tell. My amicus brief? Oh, he didn't agree with him. Oh, he liked the brief. Okay. Okay. I see. That's the problem. I should have warned him. I should have let him know. Don't do it. Don't do it. Sacrifice me on the altar. It's okay. Oh, poor guy. I don't know. I don't know. I'm going to talk to him on Friday, so we'll see. Now, I know he's been critical of Ty's handling of the case as well. So I wasn't really planning on talking to him about Vic's stuff. That wasn't really the goal, but I mean, I'm guessing it's probably going to come up at some point. So anyway, yeah, no, I can't believe they're mad at that guy. God, these people are terrible. They're just terrible. All right, Silky Johnson says, hey, Rackets, with the rulings from Roe v. Wade and Doe versus Bolton, did it strike down the democratically decided laws of the 50 states, well, it wasn't 50 states, and impose the will of an unelected court? Did it take away the say of the people? If so, how is that constitutional? I mean, well, in some way, yeah, it did. In some places, for sure. It put restrictions on what the government could restrict as far as abortion. Sure. So it did that. How is it constitutional? It's constitutional because the court said it was constitutional back in Marbury versus Madison, for the court, which does not have these powers written in the Constitution, to determine what is constitutional. The quote from Marbury versus Madison is, we say what the law is. So that's how they decided it back in 18 whatever. That's how they continue with it today. That's why. It's not a good reason, it just is. But also, it's important to note that Roe v. Wade isn't controlling law on abortion anymore. It's more of a symbolic thing. Planned Parenthood versus Casey, much more important and much more relevant to today. And interestingly, I think if we just apply Planned Parenthood versus Casey as it's written, will actually solve a lot of the abortion issues in this country really quickly. Really quickly. But we won't do that. The court's afraid to actually abide by their own ruling in Planned Parenthood, which was 1992. Also stemming from Minnesota. Jeff the Gamer says, $5 for actually having been forced to do some admin shit in the Discord. Shill that Discord. That was some good entertainment. By the way, Nicky Boy, hear anything out of Ron the Cuck Toye or Fat as a fucking whale Monica the Horseface Rial using all 255 cut? No. I haven't heard anything from them. I don't really look for their stuff either. I don't look for it. So I don't know. Someone says Casey is still bad. It is, but the cool thing about Casey is if they applied it as it's written. Planned Parenthood versus Casey would allow states to prevent abortions past fetal viability. Well, fetal viability necessarily pushes closer to conception with every scientific advancement in delivery and gestation. When Planned Parenthood versus Casey was passed, or was decided back in 1992, you had fetal viability right around the 28 to 27 week area. Since then, advances in medical technology have moved so far that we have had babies born at 20 weeks go on and live for significant amounts of time. I think 20 weeks, 4 days, 20 weeks, 5 days. Those babies went on to live normal lives, I believe, as in they're not dead yet. And so if you push fetal viability forward as you're supposed to, it will eventually phase out abortion, because eventually medical technology will be able to keep a baby alive as long as the baby will be alive. And we would have, in theory, something like an artificial womb or an incubation chamber where even a pregnancy that was extremely premature within, we'll say 8 to 10 weeks, would be able to actually be saved, technologically speaking. So that's just a product of how technology tends to advance. We'll get there eventually. That's what all the indications we have say. So if they apply that logically, it will phase out abortion necessarily, as phase out the prohibitions on abortion necessarily, and it'll allow states to make the decision again. So it's an interesting concept, but they don't do it. They still regard fetal viability at like 27 weeks, which it's much, much sooner. You can argue certainly that 20-week fetal viability or 22-week fetal viability is reasonable. It's not easy. It's certainly a difficult place to be. But when we've had babies born alive at under 21 weeks, I think it's safe to say that 22 weeks is a good point for viability, and it should push further sooner. And yeah, you see some states have laws at 20 to 22 weeks. Those are just awaiting a challenge to them, and they could be struck down. But that's why states pass those laws, is they're trying to push Casey forward. They're trying to do it. So it's interesting. It's interesting, but the Supreme Court has been hesitant to do anything with it. Architect of Fate says, just got a walking desk treadmill to fight the COOF lockdown's extra 30 pounds. But in 21 miles today, the only problem is my sack chafes against itself pinched between my now lard-laden thighs. Damn. You walked 21 miles today on your treadmill desk? Good God, I would be starving. I'd be starving. Quacky Boy says, what is love? I don't know, but baby, don't hurt me. Mario Carter 13 says, Legal Eagle on YouTube because laughed out of courtroom. Magnus says, why are you so late in gay rackets? Also, Barnes is GOAT, greatest of all time. Magnus also says, ask Barnes if he knows Kevin Landau. No. Omeow Comics says, hey, Nick, check out my Indiegogo comic, Oi, Bardic Fury 4, The Banshee Vale Horror Show. It's a fantasy comic about rock star bards and hippie cult leader druids in an Iron Age Ireland. Will you survive? I don't think so, but I hope to. Mario Carter 13 says Lynn Wood couldn't hit the broadside of the Barnes. Catastrophe says for Barnes, Demolition. Oh, sorry, I didn't get this one while he was here. Demolition Man or Blade. Also movies along the lines of Snatch and Rock and Rolla. I don't know. For me, it's Demolition Man, and Snatch is great. Gelth Walker says, testing, get reeked rackets, may Rial want your body? Ew. Cars in Depth says, what's more carcinogenic, Eddie Van Halen's metal guitar pick or Catherine Zeta-Jones's privates? Jesus criminy. Catherine Zeta-Jones's privates. Joshua Worley says, could a court compel them to censor the nudity that takes place? I think you're talking about, I don't know who you're talking about. What nudity that takes place? Yeah, I should say RIP to Eddie Van Halen. Gary Flanagan says, thoughts on Tana Mongu, hashtag booty for Biden? First of all, use a hoe. Don't send people nudes because they vote for some old person. That's weird. But I don't think she's going to get in trouble for that. I don't think she's going to get in trouble for it. Maybe she will, but I really doubt it. Even though, I mean, it is soliciting votes for change or for like a thing of perceived value. Is Tana Mongeau hot? Mongeau? I don't know who that even is. Bad Vibe says law Twitter as a group known as a pod of fail whales. WHMW says Caldwell with Fiore case. My gosh, just learned that civil procedure class. Yes, sometimes law happens on this show. Gas and Heap says, love, what are the odds? Which states are the ones to bet on electorally right now? Oh, I think that was for Barnes. Sorry, Gaston. Geldwager says, Robert must yell Will in his Uncle Phil voice. Oh. I see what you were trying to do there. Batgoat sent for Chair. Thank you. Kofi 2A wannabe Hunan Muhammad says, Chair Kun regaled us with the story of that time you had a wet fart. That's constantly. Mario Carter 13 says, Chair Kun getting more ass than Drexel. Joshua Vidrine says, Judge voice. Kermit the Frog, this court finds you guilty of being a simp for Miss Piggy. We sentence you with hard CBT. Bailiff, smack his nuts. That was the judge from Phoenix Wright that I did. E1337 Neo says, hey, Nick, so when can we get a Barnes, Beard, Hook, and Peacock Big Brain panel stream? Do it. That would be tough, I think, to organize. Razgriz Reborn says, will this set a precedent for censorship of anime like they tried in Australia and other countries? No. The law is actually, or the case I was talking about was decided back in like 2014. So it clearly hasn't done that. It doesn't work that way. That's why I was saying, and this is the joke I was making towards Hero Hey, that I was going to come up with a legal argument that hentai is obscenity, was based on this lolly case. It's a joke, but, no, it doesn't, since it's a criminal case, you can't just universally apply it as like overruling First Amendment protections. It doesn't work the way. It has to do with how the appeals court actually reviews decisions. So I don't think they didn't adequately, it appears, challenge the constitutionality of the law. Oh, you think the question about censoring the nudity was in relation to Netflix and Cuties? There isn't nudity in Cuties. The alleged nudity in Cuties is non-nipple underboob. Again, I think is inappropriate, but for some reason we have defined like female breast nudity as nipple. So it's not in there. So there isn't censorship. They can't compel them to censor something that isn't there. Black bar the zoom in. That would be the worst thing ever. I don't want the government doing that at all. We can just solve this in the market if we do it right. Let's see. Queen Nida says Nick should bring Shadman and Null to discuss the lolly subject, as well as maybe a non-informed party as a control group. That sounds awful as well. David Bowser says Cuomo is literally having police in New York City round up Jews right now, breaking capacity mandates at synagogues. Tagged you on Twitter to the video. Based, I guess, Cuomo? Wasn't he in trouble for going after Jews before? That's kind of funny. Yeah, just burn your campaigns to the ground, I guess. Let's see. Mario Carter 13 says, I would advise against penal probing children. Timmy Carl says, what is your take on Trump tweet to repeal Section 230? Repealing Section 230 is not how we should fix this problem. Not how we should fix any of these problems. Section 230 is an important thing. I think it could use some revision. But most of us, not us, I should say, I don't run a website, but most people who do run websites should have protections of 230, because for most people, the moderation of those websites is near impossible if there are multiple users. If you're a forum, like Kiwi Farms, for example, that's run by one guy and then some special individuals who go ahead and volunteer and admin for it, there's no way you can keep up with all the stuff that happens on the site. Also, I think the revision to taking out otherwise offensive material and putting in some sort of objective standard is a good thing to do. They need to do stuff like that but 230 needs to stay on the whole. It really does. Just because it happens to protect bad people from time to time doesn't mean that the good people who it does protect all the time need to get swept up in that. Derpy Jew says, what are your thoughts on Ernest Scared Stupid? I love the Ernest movies. I think I would hate them if I watched them now. Andrew War Snowboard says, every single person involved in the creation of the movie Cuties, sans actors, deserve to be sentenced to death by perpetual stone cold stunner. That's fair. Punch Sucka says, to the two people together but live on both their channels I do with Q, don't act like you haven't seen that grift on Chatterbait. Is that what they do on Chatterbait? Oh, God. Gary Flanagan, I agree that Section 230 needs major overhauls. It doesn't need to just be repealed, though. Doesn't need to just be repealed. All right, then we've got Griffin Lawrence says, hey, Nick, are you able to check out a YouTube channel called Blind Justice? The dude is a veteran and is blind. He had a court appearance, yet was blocked access to the court, and now has been arrested for failure to appear with a bond set at $50,000 home arrest. Damn. Never heard of it. Never heard of it. I could check it out, but never heard of it before. Okay. Well, guys, I think that's the Talal Al-Malki. Don't apologize. You don't have to apologize for not watching. Take care of the home front always. Always take care of your home stuff. This show is here to entertain, provide a nice escape and some laughs and education and information and anger for people. That's what it's here for. It'll be here when you come back. Don't worry about it. Take care of your home stuff always. So, all right, guys, that is the show for tonight. Monjo. Oh, okay. That is the show for tonight. We're going to go over to Twitch in just a little bit, and we will start up John Carpenter's Vampires. John Carpenter's Vampires. So, I also think, I was talking to Drexel. He may be back next week. I'm not sure. I'm going to figure that out soon. But keep an eye out for tomorrow. If I did not realize that the vice presidential debate was tomorrow, so I got to call Ty tomorrow and ask him if he's up for it. All right, guys. Thanks for hanging out. I'm going to play the outro, and then we will wrap up the show. The show will be over as soon as I fade out. So I'm going to get the outro going. Come hang out on Twitch. Otherwise, I'll see you tomorrow. Also, I got to buy Baldur's Gate 3 and start playing that. Should be fun. All right, guys. Talk to you soon. Have a good night. Peace. Peace.
Oh, he drinks a fair bit, but you realize that it just helps get his noggin jogging along. With his glass by his side and his kids asleep tight, we'll hear some lost-splaining tonight. With his microphone muted, we'll laugh at this boomer until he explains it's all part of the plan. Watch his face become redder as he becomes meta, raging at idiots from Twitterland. From the white shores of Maine to the hills of Glenlivet, there's no one who explains the law better than Nick. So pour out a glass for the ones who have passed to make the law his lady is fair, and she handles herself with the grace of one who has borne many children. As the wife of a lawman, she makes sure that he has the time and the place to provide for them there. So pour out an art bag, a bow, more of love rug. The spirits flow as the ones who get unemployed. So pour out a glass for the tea, post on Twitter as we hear Lost Planning tonight. From the white shores of Nan to the hills of Glenlivet, there's no one who explains the law better than Nick. So pour out a glass for the ones who have passed to make the law what we are now. Oh, the guests are all plentiful, from Doug T to Drexel. They bring their perspective and spice to the mix. But the reason we're here and the one that we cheer is the one who is showcasing us his career. Spirits flow as the ones who get unemployed. So pour out a glass for the tea, post on Twitter as we hear Lost Planning tonight. From the white shores of Nan to the hills of Glenlivet, there's no one who explains the law better than Nick. So pour out a glass for the ones who have passed to make the law what